Thank you, colleagues. We are about to move onto Group 12, Release of Prisoners. I call Amendment 86 in the name of Jamie Green, grouped with amendments as shown in the groupings. And I would point out that if Amendment 106 is agreed to, I cannot call Amendment 43 because of preemption. Jamie Green to move Amendment 86 and speak to all amendments in the group.
Thank you, Presiding Officer. There are quite a lot of amendments in this group covering very different themes, so I'll try and get through them as best I can with the Chamber's patience. The first amendment, 86, is the first in this group and it is around the right to attend parole hearings. Amendment 86 asserts that a victim or a victim's family member, if the person is deceased, for example, should be given the opportunity to observe parole proceedings in relation to the offender's case and potential release. It does so by adding a new section into Section 17 of the Criminal Justice Scotland Act, which states that a victim or their family member, I quote, must be afforded the opportunity to attend for the purpose of observing proceedings. This amendment does not give the right to or even force victims to participate in these proceedings or hearings, nor does it give the victim or their family member the right to speak at the hearing or to interrogate either the parole panel or indeed the offender themselves. Subsection 2 of my amendment makes clear that the chairing member of the parole board retains the power to exclude a victim or their family member from the hearing if they consider it appropriate to do so, giving some flexibility in this new right. However, in doing so, the chairperson should notify the victim or their family member in advance and, more importantly, inform them of the reason for their exclusion from these proceedings. I think that's a fair and balanced caveat to my proposal. Let me establish why I think this is needed. I think this is a right that has been long campaigned for by victims and also support organisations as well. The Parliament will be familiar of a number of very high-profile cases where a victim was excluded from parole hearings. There was one such example earlier this year, which was raised with the First Minister. That was the case of Ellie Wilson, who was excluded from her attacker's parole hearing. This was raised with the First Minister, and it is reported that in response, that he said that the decision to exclude Ms Wilson from the parole hearing was, I quote, odd, strange and not very transparent. He's right, I agree, and so do campaigners. Therefore, if the First Minister is still of the view that such exclusion is odd, strange and not very transparent, then I would encourage him and his government to support my amendment. This, of course, is a much softer proposal than I originally planned in my victims' proposals, which would have actually allowed victims to make representations in these hearings. This is simply this was actually met with quite a lot of opposition at the time around particularly the trauma-informed or the lack of trauma-informed practice, to use that phrase that's been used a lot today, that victims may actually be cross-examined if they were able to participate in these hearings. Upon conversations with victims themselves and victim support organisations, it is clear that the very least they want to do is observe these hearings. And this proposal has been welcomed by VSS, and I would urge members to consider it and also support it. Amendment 87 is another amendment that will make another change to how parole operates in practice, and that is a summary of reasons behind parole decisions. Amendment 87, if passed, would require the parole board to provide a victim a written summary of the reason behind their decision to either release or indeed not release a prisoner. The current law, the 2003 Criminal Justice Act, states that the parole board must inform a victim whether or not they have recommended release and if there are any conditions applied to that release. My Amendment 87 will go a step further. It will add a phrase which says that that information will also include a summary of the reasons for its decision at the end of that additional right which they have. It retains the original provisions to ensure that only victims who wish to receive information will receive it, which goes back to a point we've already debated. But effectively it means that the parole board must now explain to victims why they have arrived at that decision. And the reason for that is important. Victims have long felt that decisions made by the parole board often feel distant and opaque to the reality of the trauma that they've experienced. They absolutely do not feel involved in proceedings, and they often feel that no attempt is ever made to help them understand how parole boards come to these decisions. They are complex and difficult decisions, of course, but my amendment seeks to ensure that victims are given the appropriate information, not just whether a release will take place or not, and whether conditions have been imposed, but why. And these go hand in hand with my other amendments, which form part of Michelle's law, which I will now speak to. Again, this amendment is supported by Victims Support Scotland, who, quote, say, the prospect of someone being released can cause significant anxiety and distress. And where the parole board does decide to release somebody, the very least the victim deserves is an explanation of the reason behind this. And I hope Parliament will support this amendment, and I am grateful to the Cabinet Secretary for working with me on it. Let me turn to amendments 40 to 45. Presiding Officer, these form the essence of what I introduced at stage 2, which was commonly known as Suzanne's Law. Let me go through the amendments. 40 to 45 are technical amendments which enhance what was already agreed at stage 2 and passed at committee stage, which require the parole board to make the failure to disclose the location of a victim's remains must be considered when making a decision whether to release. Amendment 40 clarifies that the Scottish ministers must change parole boards to comply with the new addition that was passed at stage 2. Amendment 41 is technical drafting, which adjusts the placement of the word must in this provision, the word must being the key part of the amendment that was passed at stage 2. In other words, it is an essential requirement now for the parole board to take into account the failure to disclose that information when making their decision. Amendment 42 clarifies that the consideration only applies to decisions made on initial release, as decisions made on release after recall to prison are usually focused on breaches of bail rather than the initial decision to release or not. Amendment 43 clarifies that the provision only applies where the victim's remains have not been found. And Amendment 44 states that the provision will also apply where the parole board has a belief that the prisoner knows either where or how the victim's remains have been disposed of, or where victims' remains are located. So that covers more eventualities or possibilities than the Stage 2 amendment. Amendment 45 removes the definition of a victim from the previous amendment that I passed by clarifying the law in many regards. So there are some technical tidy-ups that we had to do. Now, I am aware that there is a debate about whether these provisions go far enough. Indeed, there have been mooted in the press the concept of no body, no parole, for example, as suggested by other amendments in this group. These are amendments which I note that Victims Support Scotland have asked the Chamber to reject. And here's why I think my amendment, which both passed at stage 2 and enhanced on at stage 3, go further and go far enough for the families that it directly affects. It mirrors the wording of Helen's Law, which was passed in England and Wales, which states that the parole board must take into account the prisoner's non-disclosure. Helen's Law has already, as worded and as replicated in the wording in this law, has already been instrumental in blocking the release of killers. For example, the killers of Linda Rozelle, Julie Patson and Danielle Jones, whose releases were all blocked as a direct result of the introduction of Helen's Law and, by default, the wording of Suzanne's Law. So this approach works in practice. We've seen that from what happened in England and Wales. And if that's not enough, then I want to let those families who will be most directly affected by this know that we have been listening as a Parliament to their thoughts and feelings on this. It's been hugely traumatic for them to live through these experiences, and then for this to be played out both in Parliament but also in the media so much in the last few months. But to Carol Gillies and to Gail Fairgrieve, I want to say a huge thank you for meeting with myself, meeting with my team, meeting with Victims Support Scotland and the Cabinet Secretary, and helping us shape these amendments to get to a place that they are comfortable and happy with them. They wrote to me and they want me to say this about these amendments, and I want the Chamber to hear their words, not mine, and I want this to be on the official report. Carol and Gail said the following: We understand there may be some people in the room who consider that this amendment is not strong enough or necessary. We've seen the headlines. We've listened to the lawyers who say that this will not make any difference. But this amendment is a first step, and we want it publicly known that we wholly support it. Now, this may not result in the finding of Arlene or Suzanne. However, it does give us a great sense of peace to think that this could help keep the two men found guilty of their murders behind bars. Frankly, Presiding Officer, if it's good enough for them, then it is good enough for me. My last two amendments in this group relate to Michelle's Law, and you will note, as I've often stated, these laws have a name attached to them: Suzanne's Law, Michelle's Law, Helen's Law and others, and they all relate to the female victims of horrific crimes and the repercussions and the effect that this trauma has had on their family. And that's really what has driven me throughout this whole process over the last 3 years, to ensure that Suzanne's Law and Michelle's Law are introduced insofar as they could be, in a competent fashion that has a meaningful effect and will benefit victims of similar crimes in future. And that's really what has driven these amendments. 47 and 48 incorporates the lion's share of Michelle's Law into this bill. 47 I'd like members to focus on. It's a really important one. It states that the Parole Board must, again I use that word carefully, must take into account the safety and security of victims and their families as a primary consideration before deciding an offender should be released, whether an offender should be released or not. It does this in the same way as my Suzanne's Law provisions, by requiring ministers to make provision that require the Parole Board to take the safety and security of that family into account. Amendment 48 covers the second part of Michelle's Law, and that is around exclusion zones. Exclusion zones are a vital tool in maintaining the safety of victims and their families after someone has been released. In practice, this amendment will ensure that the Parole Board now must consider whether an exclusion zone is suitable ahead of that person's release as part of their licence conditions. Of course, this is named after Michelle Stewart. Michelle, sadly, was murdered by her ex-partner, Presiding Officer, and her family have been campaigning for years to ensure that the voices of them and other victims are heard during parole proceedings, and that the safety, security and well-being of families are at the forefront of all decisions made by the Parole Board. These amendments do just that. They're not the end of the journey. Those families want the government to go further in strengthening the victims' and their families' rights around parole, but I think it's a good start, and I hope all members will consider them positively. Thank you.
Thank you. I now call Russell Finlay to speak to Amendment 106 and other amendments in the group.
Thank you, President Officer. There can be surely nothing worse than to lose a loved one to murder, but there are families whose suffering is worse and in fact is never ending, and they are the ones who have lost a loved one to murder and cannot lay them to rest because the killer refuses to disclose the whereabouts of their remains. Suzanne Pilley, Margaret Fleming, Arlene Fraser, Alison McGarrigle, Patricia Henry, all women murdered in Scotland, and whose remains have never been found. And of course, Suzanne's Law is named after Suzanne Pilley. I think we should commend the police and the Crown Office in securing these convictions when the past presumption was, with no body, there was no conviction. And the turning point came in 2003 with the first successful prosecution for the murder of Arlene Fraser, and the others followed from that. Now, I've long campaigned in Suzanne's Law since giving evidence that helped convict the killers of Margaret Fleming. That was in 2019. One of her killers has since died in prison. One of them is still in custody. And I don't believe that that killer should be allowed to get out until they do the decent thing, the right thing, and disclose the whereabouts of Margaret's remains. Put simply, I believe in the absolutism of no body, no release. I'm concerned about some of the long-term spin there has been around this legislation. It's been getting talked about for years. As far back as 2019, the time of the Margaret Fleming trial, Humza Yousaf set out proposals to allow the Parole Board to take into account a prisoner's failure to disclose. And there have been various similar headlines in all the years since, including ones around today's amendments in the name of other members. But there's a potentially critical problem. The other amendments before Parliament say that the Parole Board must, instead of may, take non-disclosure into account. There are very real concerns, despite what's happened with the legislation elsewhere in the United Kingdom, that this will be subject to legal challenge and will be unsuccessful. I want it to work on behalf of all those families. But my amendments, numbers 106 and 107, would ensure that. I spoke with one family today, and they agree that rather than taking a risk on a potentially weaker version that might be open to a successful legal challenge, we should be bold and we should empower the Parole Board to explicitly prevent release without disclosure of where a body is kept, as has happened in many other places around the world. So 106 and 107 do much the same thing. 106 does it by way of amending an amendment within the bill, and 107 does it more completely, I suppose, by way of legislative description, full legislation that would give the Parole Board the right to use that as a reason to prevent someone, a killer, from being released. Now, these cases are extremely rare, but they are horrific. They're unthinkable. I spoke with one victim of who's a passionate advocate for Suzanne's Law, and that's a man called Colin Higgins. Colin was abused in childhood by 2 paedophiles, and then when he confided in a female friend called Alison McGarrigle, she was murdered by the 2 paedophiles who are now in custody, and at some point they will come up for parole, and there's no way, I believe, they should be allowed out until they disclose the whereabouts of Alison's remains. And Colin firmly believes in this Parliament taking the bold and necessary step to give the Parole Board the unambiguous power to keep a killer behind bars. So please, let's remove any risk of the amendments not having sufficient teeth and back 106 and 107. Thank you.
Thank you. I call Liam Kerr to speak to Amendment 46 and other amendments in the group.
Thank you, Presiding Officer. Amendment 46 is a simple but far-reaching and important one. At the moment, a prisoner on a life sentence or who is subject to an order for lifelong restriction can be considered for parole. The process involves notification of victims, at least one hearing that the victim can attend, representations from the victims at that hearing, and uncertainty for all involved. If parole is refused, the prisoner then needs to wait a maximum of 2 years before the next consideration. Now, my amendment makes a simple yet crucial change. It simply extends the maximum period that such a prisoner must spend between failed parole bids from 2 years to 3 years. Presiding Officer, this Parliament will know who Linda MacDonald is. A savage thug was already on a life sentence for murder, yet had been let back on our streets. He viciously attacked Linda and left her for dead. And in powerful and compelling testimony, Linda says she lives with the dread that every 2 years the killer is considered for parole. She says, as do many victims, that the regularity with which the victims, need to interact with the parole system is one of the drivers of re-traumatisation in the current setup. And it will not be lost on anyone in this chamber that the primary function of this new bill, one of the primary functions, is to make the entire Scottish justice system more trauma-informed. Presiding Officer, Tasmin Glass was sentenced to 10 years for her role in the 2018 murder of her ex-boyfriend, Stephen Donaldson, in Kirriemuir. She was granted parole halfway through her sentence under strict conditions, but she was returned to prison in early 2025. However, almost immediately, she was eligible for parole again. And there followed several hearings at which she might have been released again, hearings for which various reasons came about and didn't consider the substantive issues, or indeed come to a decision. I cannot imagine the trauma and indeed re-traumatisation caused to Mr Donaldson's family. They have described everything about this, from the early release to the repeated parole hearings and delays, as a disaster. Presiding Officer, this is appalling. Victims are constantly 1 year away from preparing for the next parole hearing or dealing with the aftermath of the last one, with all the trauma and resurfacing of emotions that will naturally bring with it. This is no way to treat anyone, let alone victims of crime, the bereaved, the appallingly wronged. 3 years is probably still too short in my view, to be honest, but would at least allow, in most cases, a safe harbour of 1 year either side for victims in preparing for the hearing or dealing with the traumatising aftermath of the hearing and the relitigating of their experience. Now, the Cabinet Secretary has written to me on this amendment and put some points to me. She says she can't support my amendment because the current timescale of 2 years is current practice throughout the UK. Presiding Officer, I'm afraid the irony of an SNP government member arguing they want to maintain alignment with the UK over doing the right thing will not be lost on anyone in this chamber, particularly given that this bill before us today introduces jury majorities and a standalone sexual offences court that are completely unheard of elsewhere. The Cabinet Secretary also puts to me that she's concerned this amendment could be open to legal challenge, presumably from convicted killers on life sentences. Well, I counter, Cabinet Secretary, that prisoners can already be locked up for life, even under the ECHR, as we can see from England having had whole life orders that provide for this for decades now. Indeed, in the last session, when I proposed my whole life sentences bill, the government was very quick to argue that keeping people locked up for longer is already an option. It's already legitimate in Scotland. And besides, members in this chamber will be well aware this is a government that is never shy of going to court at the drop of a hat to defend policies from legal challenges. Just this weekend, we heard they have been taken back to court for their refusal to properly implement a Supreme Court verdict. Now, I can't help feeling that the public would far rather their government was going to court to fight for killers and rapists to stay behind bars for longer than some of the matters they've chosen to litigate recently. Presiding Officer, we are talking about incredibly dangerous, violent or sexual offenders who've either been locked up for life or have been given an order that says they present a continuing danger to the public. The period before reconsideration of parole should be 3 years. And I come back to Linda MacDonald in conclusion. And who would know better than someone who has been through this experience? Who has said, Linda MacDonald has said, an increase to 3 years would be a step in the right direction. We can and should debate whether it should be increased still further. But today, the government must listen to survivors and make this common sense change to protect victims and the public. And so I have pleasure in moving Amendment 46 in my name.
Thank you. And I call the Cabinet Secretary to speak to Amendment 162 and other amendments in the group.
Thank you, Presiding Officer. I understand and appreciate how difficult, stressful, turbulent, traumatic it can be for victims and their families when the offender linked to their case comes up for parole and potential release. I have met many victims who have shared their personal experiences with me and their views on where they feel the system can be improved to better support them during this stage of the justice process. We all want to ensure that victims and their families are informed about how and why decisions are made, and to have an effective system in place for the release of prisoners, which keeps victims and their families informed and supported, while maintaining confidentiality and the integrity of decisions and the safety of all involved. And I have done, and I'm very pleased to have done, significant work with Jamie Green on the issues he has raised, and on parole in particular, agreeing amendments he brought forward at stage 2 and working with him on amendments 40 to 45 and 47 and 48 in this group. The member has long campaigned on these issues, and this package of amendments seeks to strengthen the factors that the Parole Board and, where relevant, Scottish ministers must take into account when considering release and licence conditions. And I am deeply aware of the continued distress for family and friends of the victims in cases where the location of an individual's remains is unknown. And I recently met with the families of Suzanne Pilley and Arlene Fraser, and my deepest sympathies remain with them and any other family in this situation. Amendments 40 to 45 do not change the effect or rationale of the provisions that was accepted in this area at stage 2. More, they provide further clarity on the specific legal drafting to ensure that if there are reasonable grounds to believe that the prisoner has relevant information that would help locate the remains and has not disclosed that information, this must be taken into account by the Parole Board. And I am also willing to support Jamie Green's Amendment 87, as it will ensure that all victims, not just those of indeterminate cases as the current system allows, will get a summary of the reasons why a release decision has been made by the Parole Board. However, I am also aware that parole was a new topic at stage 2, and there are a number of issues where I think further consideration and further work is required. And I do believe that the parole system can be improved, which is why I announced during stage 2 that we were planning to publish a consultation on parole reform, which we did on the 20th of August. The consultation, Voices in Justice, a consultation on parole reform in Scotland, will enable us to gather a wide range of views and develop a suite of reforms to the parole system that Parliament can fully consider as one package. And this will ensure that any changes that are required work together as a system operationally and, of course, are legally feasible. This, I believe, is better than a piecemeal approach. For these reasons, I cannot support Amendment 86 today, although I can reassure the member that Parole Board hearings are part of the consultation, and I urge him not to move the amendment to enable these views to be heard. Presiding Officer, let me turn to Amendments 106 and 107 in the name of Russell Finlay, which effectively require that a prisoner held in custody indefinitely until they provide certain information. As I previously set out, I know how important an area this is for victims' families in these very traumatising cases. This is why the Government is supportive of Jamie Green's amendments in this area, as are victim support organisations. And for me, this issue goes back to amendments that Mr Green brought at stage 3 in the Bail and Release Bill in 2023, and at that time I gave a commitment to continue to engage with him on this matter, and I'm glad that we have been able to take this forward to the satisfaction of the families that he is representing. However, it is the position of the Government that decisions on risk and release do have to be made on a case-by-case basis by the Independent Parole Board, who may take all relevant information into account. In addition, these amendments could lead the Parole Board decisions being more vulnerable to legal challenge. And I don't say that lightly, because I am acutely aware that legal challenge adds risk as opposed to remove risk, and also adds to the pain and trauma for families. And I just, in this regard, and I say with respect to Mr Finlay, I just can't play fast and loose with families in this regard. And therefore I cannot support Amendments 106 and 107, and I urge members not to support them. Of course.
Russell Finlay.
Does the Cabinet Secretary not recognise that by giving the Parole Board the powers that make this absolute, it reduces the risk of legal challenge? And does she not surely accept that I have absolutely no intention of playing fast and loose with families of victims?
Cabinet Secretary.
Presiding Officer, and I actually didn't say this. What I said to Mr Finlay is that I will not be playing fast and loose with families and victims. And as I've already said, anything that we bring forward in this area has to be legally robust. And I'm not going to compromise on that. I understand your position, Mr Finlay. I understand it very well. But at the end of the day, we have heard from Mr Green, and we are delivering what we can that's within legal, without legal risk, to give at least some comfort to families. This is a big step forward, and I'm very pleased that we've been able to make progress on Helen's/Suzanne's law, that we've made progress on providing our support for amendments on the summary of reasons, on exclusion zones, and writing into legislation that the Parole Board must consider the security and safety of victims and their family. This is a significant package of reform in this section of the bill, but of course the consultation on parole will allow us to go forward, to do more, to have that full consultation on the areas that require further examination and further work, and of course changes that are agreed can be brought forward by statutory instrument to amend the Parole Board Scotland rules. I also do not support Amendment 46 proposed by Mr Kerr, which seeks to increase the maximum length of time an offender subject to a life sentence or order of lifelong restrictions is required to serve between their parole reviews from 2 years to 3 years. Again, I understand why he's brought this forward, because of the impact that hearings have on families and that uncertainty and that trauma. But my reasons are very similar to why I can't support Mr Finlay's amendments in 106, 107, because it is important that we are confident that any changes made as part of this bill can withstand legal challenge. I do not have that confidence in this instance, and it's only right that I'm candid about that, given that there is existing case law and practice throughout the UK that suggests 2 years is a suitable frequency, and I urge Parliament to oppose this amendment. I'll give way.
Liam Kerr.
Very grateful. Quite clearly, I'd be interested in seeing it. I know she won't disclose any legal advice that's been taken, but perhaps she could set out to me either today or following this debate the legal advice and the legal rationale behind rejecting my 3-year period.
Cabinet Secretary.
Well, as I've already informed Chamber, that there is existing case law and practice throughout the UK in regard to this. And to pick up an earlier point raised by Mr Kerr, the reason that people it is legally competent for people to stay in prison for lengthy periods of time, and indeed decades, is because they are subject to regular reviews following their punishment part. Presiding Officer, finally, my own Amendment 162 amends the long title of the bill to reflect amendments in this group. Thank you.
Thank you. I'll just remind members to speak through the chair always, and I call Jamie Green to wind up and press or withdraw Amendment 86.
Thank you, Presiding Officer. Can I thank members for their contributions on what are quite sensitive issues? I'll start with the issue of Suzanne's law, Presiding Officer. I appreciate I had a lot of amendments to talk to in that first section, but I want to cover one or two issues in closing, if I may. I want to be clear to the families affected by Suzanne's law, because I know they're watching, because I met them on Friday last week, and they said they'd be watching carefully at today's debate and the vote tomorrow. I want them to be clear that we are passing Suzanne's law if our amendments pass. What was passed at stage 2 was supported by all parties in this chamber. Indeed, I may have been sitting on the opposite benches, but in the hours that followed the stage 2, there were press releases and social media graphics that went out to say that Suzanne's law was passed. If it was good enough then it's good enough today, I would argue. It doesn't matter where you're sitting in this chamber. It's important that we get this legislation right. And I also want to say to them that there were concerns about legal challenges. The legal challenges are more of a concern if the other amendments that are being proposed pass. And that's direct feedback from the families, and that is replicated in the briefing from Victim Support Scotland that they sent us. They say that they welcome Amendments 40 to 45 today. They welcome the proposed change of may to must. And they firmly believe that these provide a workable legislative solution and progress that families welcome. And families do welcome it. In fact, since speaking at the opening of this part of the debate and my closing summing up, I had a message passed to me from Marie McCourt, MBE. Marie is 81 years of age, and she's the mother of Helen, after Helen's Law was so named. And she's asked me to share this with the Chamber just in the last 10 minutes. She said, when I was fighting for Helen's Law, critics and sceptics said it wouldn't make a difference. Believe me, it does, and it has. Due to parliamentary delays in Westminster, my daughter's killer came to the Pro Board before Helen's Law was adopted. And to her horror and disbelief, he was released. It was a decision that nearly destroyed me, she said. As a result of Helen's Law, it is now a legal requirement for prisoners applying for parole to be questioned about non-disclosure. She goes on to say, families of the missing murdered are not vindictive people. We do not wish to see killers locked up forever. All we want is information that will lead to the recovery of our loved ones' remains, so we can bring them home and lay them to rest. For the sake of victims and families, I urge members of the Scottish Parliament to pass this crucial, essential piece of legislation. If it has Ms McCourt's support, if it has the families of Arlene and Suzanne, if they're in support of it, then I am supportive of it, and I hope the Chamber is too. Finally, on Michelle's Law, there are 3 tests that I set the Government ahead of today. 1, that the safety and security of victims is the primary consideration for the Pro Board ahead of someone's release. 2, that the use of exclusion zones are enhanced and increased, and they form a vital part of that decision-making process. But again, not just the safety and security, that's the physical safety and security, also the mental well-being of those families as well. And again, that now is in this draft of my amendment. And finally, more transparency in the Pro Board's decisions. Amendment 87 does that. They will now be required to publish decisions for parole, decisions that previously were never given to victims or their families. All of that in the round, in my view, delivers on Michelle's Law. It delivers on Suzanne's Law. And if you strip away all the politics, surely that's what this whole bill is about. Improving in law that is competent, workable, legislatively sound, and commands the support of Victim Support Scotland and the families that have been directly affected by deficiencies in the law to date. That is what I've sought to achieve, and I believe that that is what we deliver with my suite of amendments, and I urge the Parliament to support them.
And I confirm, Mr Green, that you wish to press or withdraw Amendment 86.
Amendment 86, I've reflected on the Cabinet Secretary's comments and will not move it.
Thank you. Jamie Green seeks to withdraw amendment number 86. Does any member object? No member objects. I call amendment 87 in the name of Jamie Green, already debated with amendment 86. Jamie Green to move or not move?
Moved.
Thank you. The question is that amendment 87 be agreed to. Are we all agreed? Yes. We are agreed. We move on to... Okay, I'd be grateful if members could shout very clearly. Thank you. The Parliament is not agreed, therefore, with regards to Amendment 87, and there is a division, and I would ask members to cast their votes now. The vote is closed. The result of the vote on amendment number 87 in the name of Jamie Green is yes 97, no 19. There were no abstentions. The amendment is therefore agreed. We move to Group 13, Fixed Penalties. I call amendments 105 in the name of Sharon Dowie, grouped with amendments 105A, 105B, 105C, 105D, 105E and 53. Sharon Dowie to move amendments 105 and 105A and speak to all amendments in the group.
Thank you, Presiding Officer. My Amendment 105 would provide for a much-needed review to be conducted about the statutory entitlement of victims to receive information and fiscal fine penalties. Specifically, it would look at the information provided about whether fiscal fines have been accepted or rejected by offenders and the reason given by alleged offenders as to why the fiscal fine was accepted or rejected. Victims deserve to be told this information. This is intended to be complementary to Liam Kerr's Amendment 53, which he will explain shortly. It would be for the Scottish Ministers to prepare and publish this review within 2 years of this provision coming into force. I am grateful that the Government have worked with me on this, and my additional amendments 105A to 105E make minor changes to ensure Scottish Government support, and can also thank you, Presiding Officer, for allowing the submission of the late amendments. And I move the amendment. Thank you.
Thank you. I call Liam Kerr to speak to Amendment 53 and other amendments in the group.
Thank you, Presiding Officer. My Amendment 53 would ensure that an offender is prosecuted where they reject an offer of a fiscal fine as an alternative to prosecution. Colleagues, fiscal fines are commonly used to deal with crimes, including common assault, shoplifting, antisocial behaviour, certain sexual crimes and drug supply and possession. An offender can, in some circumstances, be offered a fine of up to £500 instead of being taken through the court process. Presiding Officer, a third of those cases in the last year, so where an offender had rejected an offer of a fiscal fine, resulted in no further action. Those figures have remained roughly the same for years. In other words, a crime has been committed. The judge says, you'll pay a fine. The criminal says, no, I don't want that. And that's the end of it, in 1 in 3 cases. Now, in this very place, in 2021, John Swinney himself explained that where a fiscal fine has been refused, the refusal is treated as a request by the alleged offender to be prosecuted for the offence. Apparently not. And it cannot be a surprise, given that 1 in 3 people in these cases get off completely free, that in the year to June 2025, all of those crimes that I listed have rocketed. Now, the Cabinet Secretary, in a very helpful letter to me earlier, counters that prosecutors have duties to continue to review whether prosecutorial action is in the public interest. But the Cabinet Secretary must surely concede it cannot be in the public interest to let criminals get away with no punishment at all, particularly where the very crimes for which this system is supposed to be used are skyrocketing. And since, as far as I can establish, there is no data as to the reasons why these matters were dropped altogether, that is to say, what was the public interest that was considered and found to be persuasive in the rejection of the use of prosecution, I'm afraid, Cabinet Secretary, the argument from public interest is founded upon sand. And therefore, Presiding Officer, my Amendment 53, which I hereby move, will ensure that no one can get away with breaking the law without consequences, just as the now First Minister said should be the case.
Thank you. I call the Cabinet Secretary.
Presiding Officer, I am pleased to be able to support Amendment 105 from Sharon Dowie as adjusted by Amendments 105A to 105E. Other parts of today's debate have examined proposals to enhance the information that victims are entitled to, particularly victims of serious offending. And I recognise the members' desire to ensure that we are not complacent when it comes to victims' rights where their cases are dealt with by fiscal fines, and it is right that ministers review and identify if legislative changes are necessary to afford better outcomes for victims. Therefore, I am pleased to support this amendment if amendments 105A to 105E are also agreed. However, I cannot support Amendment 53 from Liam Kerr. Figures from the Crown Office and Procurator Fiscal Service show that over the last 6-year period, where charges are dealt with by fiscal fine, 90% are paid, deemed accepted or are subject of ongoing proceedings. In the year 23-24, of over 12,000 charges in which a fiscal fine was offered, only 368, that's 3%, were refused and then marked for no further action by prosecutors. So this amendment is therefore targeted at an extremely small minority of cases dealt with fiscal fines and, in my view, is unnecessary for a number of reasons. Because there are a number of reasons why independent prosecutors, after initially marking a case for a fiscal fine, may decide to take no further action if that fine is refused. And it is absolutely right that they have the power to do that. These decisions are made on an individual case-by-case basis. They are based upon assessments of evidence and the public interest. And examples of reasons for no action after the refusal of a fine include where further evidence has been provided that undermines the Crown's evidence or indicates that the accused did not commit the offence, or where there is no longer a sufficiency of evidence for whatever reason, including where a witness has died, or where the circumstances of the accused, such as significant ill health or death, mean that prosecution is not possible or in the public interest.
Liam Kerr.
Very grateful. The Cabinet Secretary adduces the reasons why this might happen. She does not produce data to say why it is happening. So perhaps she could provide that to the Chamber.
Cabinet Secretary.
Well, Presiding Officer, there is data produced by the Crown Office, and I'm also aware that the Lord Advocate very regularly writes to the Criminal Justice Committee on these matters. But if I can reassure Mr Kerr that, as I have indicated, prosecutors do have an ongoing obligation to consider any change in situation at any point. And due to that, the requirements of this amendment would mean the notification to an accused would not always be accurate and would in fact misrepresent the role of the independence of prosecutors. If the intention of Amendment 53 is to actually bind prosecutors to take action to prosecute in all cases where a fiscal fine is refused, then it is out with the competence of this Parliament due to the independence of the Lord Advocate. And we must also recognise that not all of those offered a fiscal fine will have committed an offence, and if fresh evidence is available, prosecutors should be able to take that into account when deciding what action to take after a fiscal fine is refused. And I appreciate that members are keen to understand how fiscal fines are used, and as I said earlier, the Lord Advocate has been writing to the Criminal Justice Committee at regular intervals with updates. Presiding Officer, fiscal fines should be seen as an important measure providing a proportionate response to lower-level offending. Prosecutors must continue to have the discretion and flexibility to make decisions on their use independently. And for these reasons, I cannot support Amendment 53 and urge Parliament to oppose.
Thank you. I call Sharon Dowie to wind up and press or withdraw Amendment 105A.
Nothing else to add, and I move.
Thank you. Can I confirm, Ms Dowie, that you wish to press Amendment 105A?
Press amendment, yes. Thanks.
Thank you. The question is that Amendment 105A be agreed to. Are we all agreed? We are agreed. I call Amendment 105B in the name of Sharon Dowie, already debated with Amendment 105. Sharon Dowie, to move or not move? What was moved? Moved. Thank you. The question is that Amendment 105B be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 105C in the name of Sharon Dowie, already debated with Amendment 105. Sharon Dowie, to move or not move?
Move.
Thank you. The question is that Amendment 105C be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 105D in the name of Sharon Dowie, already debated with Amendment 105. Sharon Dowie, to move or not move?
Move.
Thank you. The question is that Amendment 105D be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 105E in the name of Sharon Dowie, already debated with Amendment 105. Sharon Dowie, to move or not move?
Moved.
Thank you. The question is that Amendment 105E be agreed to. Are we all agreed? Yes. We are agreed. Sharon Dowie, to press or withdraw Amendment 105 as amended?
Press.
Thank you. The question is that Amendment 105 as amended be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 40 in the name of Jamie Green, already debated with Amendment 86. Jamie Green, to move or not move?
Moved, and happy to move 40 to 42 on block if it's helpful, Presiding Officer.
Thank you. The question is that Amendment 40 be agreed to. Are we all agreed? I think as it's quicker to proceed as we were, I will continue. I call Amendment 41 in the name of Jamie Green, already debated with Amendment 86. Jamie Green, to move or not move?
Moved.
Thank you. The question is that Amendment 41 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 42 in the name of Jamie Green, already debated with Amendment 86. Jamie Green, to move or not move?
Moved.
The question is that Amendment 42 be agreed to. Are we all agreed? We are agreed. I call Amendment 106 in the name of Russell Finlay, already debated with Amendment 86. And can I remind members that if the Amendment 106 is agreed to, I cannot call Amendment 43 due to a preemption. Russell Finlay, to move or not move?
Move.
The question is that Amendment 106 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 106 in the name of Russell Finlay is yes 45, no 71. There were no abstentions. The amendment is therefore not agreed. I call amendment 43 in the name of Jamie Green, already debated with amendment 86. Jamie Green, to move or not move?
Moved.
The question is that amendment 43 be agreed to. Are we all agreed? We are agreed. I call Amendment 44 in the name of Jamie Green, already debated with Amendment 86. Jamie Green, to move or not move?
Moved.
The question is that Amendment 44 be agreed to. Are we all agreed?
Yes.
We are agreed. I call Amendment 45 in the name of Jamie Green, already debated with Amendment 86. Jamie Green, to move or not move?
Moved.
The question is that Amendment 45 be agreed to. Are we all agreed? We are agreed. I call Amendment 107 in the name of Russell Finlay, already debated with Amendment 86. Russell Finlay, to move or not move?
Not moved.
Thank you. The amendment is not moved. I call Amendment 46 in the name of Liam Kerr, already debated with Amendment 86. Liam Kerr, to move or not move?
Moved.
The question is that Amendment 46 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 46 in the name of Liam Kerr is yes 28, no 86. There were no abstentions. The amendment is therefore not agreed. I call amendment 47 in the name of Jamie Green, already debated with amendment 86. Jamie Green, to move or not move?
Moved.
The question is that amendment 47 be agreed to. Are we all agreed? Yes. We are agreed. I call amendment 48 in the name of Jamie Green, already debated with amendment 86. Jamie Green, to move or not move?
Moved.
The question is that amendment 48 be agreed to. Are we all agreed? Yes. We are agreed. We move on to Group 14, Connected Proceedings. And I call amendment 108 in the name of Russell Finlay, grouped with amendments 152, 152A, 152B and 152C. Russell Finlay, to move amendment 108 and speak to all amendments in the group.
Thank you, President Officer. This is a clean, simple and necessary amendment. It's informed by victims' experience of the justice system and specifically crime victims, very often victims of domestic violence and abuse, who suffer prolonged and traumatic ordeal of a criminal justice prosecution process, are often then subject to simultaneous civil proceedings. And there have been some real horror stories. Women dragged through the small claims court by men who abused them, or women subject to civil cases in relation to child custody, for example, by the very same men who abused them. Abusers often use the civil courts to delay the criminal proceedings and vice versa, and this causes further painful delay. The civil actions can often be weak or downright vexatious. Effectively, what happens is these men weaponise the criminal justice system to continue their abuse against their victims. And there's even a name for this. It's called legal system abuse. And we can fix it today by seeking that the same sheriff or judge should hear parallel civil and criminal cases when they're going through the courts. This would give the courts critical information and would curtail such system abuse. Now, at stage 2, I put forward an amendment on the similar theme, but did not move it. And in my questions to the Justice Secretary at the time, she was fairly cryptic about whether or not the judiciary were in favour of this or not. And we now know the answer, that they don't like it, because we've since seen a letter from the Lord President to the Parliament's Criminal Justice Committee. Now, I won't address all of his points in the letter or the points that were put to me by the Cabinet Secretary at stage 2, but suffice to say that what we are proposing would be entirely subject to judicial discretion. And I will make 2 points. First one is, this amendment simply requires the Lord President or the Sheriff Principal to, and I quote, have regard to a single judge or sheriff hearing parallel cases where that is possible and where that is practical. And this amendment is therefore not political interference in the independent judiciary. And I'm grateful for the comments the Cabinet Secretary made at stage 2, in which she said to me, I agree that you have attempted not to interfere with the independence of the judiciary. This amendment is backed by Victim Support Scotland and Scottish Women's Aid. Victim Support has said, every sheriff I have spoken to thought it was a good idea. And Victim Support Scotland said, women, children and young people are endangered and harmed through the courts, making decisions without information and understanding of the context and abuse. And they said that in support of this amendment. They recognise that this amendment is clean, simple and effective. It would do exactly what it sets out to do, and it would make a very real difference to victims in the real world. So I'd urge all members to back my amendment number 108, which I move.
Thank you, Mr Finlay. I now call Maggie Chapman to speak to Amendment 152 and other amendments of the group. Ms Chapman.
Thank you very much, Presiding Officer. I'm grateful to the Cabinet Secretary for the discussions we've had about this issue, especially as I try to get a more prescriptive amendment, quite similar to the one Russell Findlay has just moved, into the Criminal Justice Modernisation and Abusive Domestic Behaviours Review Scotland Bill at stage 2. But I'm glad that we can have this discussion about it here. I should say that I'm also grateful for that the manuscript amendments 152A to C have been accepted for debate this evening. They mean a clearer amendment that requires a review to take place within 2 years of this section of the Act coming into force. We know that, sadly, in many criminal cases of domestic abuse, there are parallel civil cases that are required to deal with questions of child contact, guardianship and the like. Victim survivors have said that the lack of communication between criminal and civil cases that are clearly connected is a source of great distress. Scottish Women's Aid have been campaigning on this issue for a very long time. The connected issues of domestic violence, child protection and child contact are not well considered in our current justice systems. And this is a cross-jurisdictional problem. A recent England and Wales report describes how victims and survivors of domestic abuse don't feel understood or taken seriously in the family court. In the Scottish context, the issue has been discussed by the Law Society, the Commissioner for Children and Young People and others. A recent report by the Scottish Centre for Crime and Justice Research identified key problems, including a lack of mechanisms to communicate information between different court proceedings and a limited and siloed understanding and consideration of domestic abuse by the judiciary. There have been various recommendations made, some of which have been implemented, but we know that the problems persist at huge cost to the well-being of women and children. Scottish Women's Aid suggested the solution that, where possible, the same sheriff would hear both the domestic abuse and child contact cases. This would make it much more likely that the evidence of abuse and its effects would be properly considered in all their depth and breadth. It would help bridge the current disconnect between the child protection, child contact and domestic abuse issues, and it would prevent the manipulation, coercion and ongoing abuse of victim survivors. I appreciate that the Scottish Government is probably not willing to support this approach as outlined by Russell Findlay's amendment just now. So my Amendment 152 seeks a review of connected proceedings. This review would consider how best to share information, whether shared jurisdictions would be helpful and appropriate, among other things. I also hope that these discussions could identify what else might be done in the shorter term to improve the connections between related criminal and civil cases. I'm confident that the collective intelligence in both our legal and political systems can determine a way through this knotty problem so that we can better support and protect, particularly women and children, in domestic abuse and child contact situations. Thank you.
Thank you, Ms Chapman. And I now call on the Cabinet Secretary.
Presiding Officer, Amendments 108, 152 and Manuscript Amendments 152A, 152B and 152C are about the interface between the criminal and civil courts in relation to domestic abuse. The Scottish Government can support Amendment 152 as amended by Amendments 152A, 152B and 152C, but not Amendment 108. I fully recognise that the criminal-civil interface in relation to domestic abuse is more than worthy of further consideration, which is why the Scottish Government is already doing work in this area. We are already carrying out further research on integrated domestic abuse courts, which will be published early next year. In addition, we have an ongoing programme of work using improvement methodology. I've also written to the Criminal Justice Committee recently seeking their comments on a draft policy paper to go to the Scottish Civil Justice Council proposing civil court rules. And we will progress this year an SSI under Section 102 of the Court Reform Scotland Act 2014 to give the courts the power to make an order in relation to a person who has behaved in a vexatious manner in civil proceedings. Mr Finlay's Amendment 108 is in the same terms as the amendment he lodged at Stage 2, which he did not press. The Lord President, as we know, has recently written to the Criminal Justice Committee to outline major concerns with what Mr Finlay is proposing. In particular, the Lord President raises concerns about potential delays and scheduling issues and says that the amendment, and I quote, would impose unmanageable burdens. Presiding Officer, we need to work with the courts, not against them, and I would urge Parliament to reject Amendments 108. I am happy to support Amendment 152 as amended by Amendments 152A, 152B and 152C to carry out a review and provide a report to Parliament. Of course.
Russell Finlay.
Just in terms of the Lord President's position about this imposing unnecessary burdens on the court, surely that's completely contradicted by the amendment which just says that the sheriff or the judge should have regard to having a single sheriff or judge presiding.
Cabinet Secretary.
Presiding Officer, I do of course appreciate Mr Finlay's interest and views on this matter, but I also, I'm sure you'll understand, have to give consideration to the views of the Lord President, who says, I quote, however, this potential amendment is counterproductive and at odds with the trauma-informed approach that all of us so strongly support. And then he goes on to say this amendment would entail wholesale reshaping of the way that the courts operate in both civil and criminal cases, and inevitably he is concerned about extended delays. I was frank with Mr Finlay at Stage 2 and was very clear about the work that I wanted to see progressed on this matter, but it's also an area that work has to be done, and it has to be done properly, and I don't think, particularly given the Lord President's views, that there are any shortcuts to this matter. As I've said, I'm happy to support the amendment and manuscript amendments in Maggie Chapman's name. It will be of use to explore further whether more information should be shared between the criminal and civil courts in relation to domestic abuse, how this information should be shared, and whether criminal courts dealing with domestic abuse offences should have jurisdiction over related or connected civil proceedings. I do see merit in the arguments for integrated courts dealing with civil and criminal aspects of domestic abuse, but we do need to ensure that we have thought through the issues carefully, and vitally that we work closely with the courts on potential models. Therefore, I invite Parliament to reject Amendment 108 and to accept Amendments 152, 152A, 152B and 152C.
Thank you, Cabinet Secretary. I call on Russell Finlay to wind up and to press or withdraw Amendment 108.
I suppose just to repeat the point that this is not imposing any burden on the courts or the judiciary. The Cabinet Secretary accepted at Stage 2 it wasn't meddling in the independence of the judiciary. It causes the judiciary to have regard to the implementation of a single sheriff or judge where there are parallel criminal and civil cases. I've heard absolutely no good reason for this not to happen, and I don't think the victims will be particularly assured by workshops or talking shops or any such thing. If I have time, yes.
Audrey Nicholl.
I thank the member for giving way, and I think we all understand the point that the member is making, but again, if I can refer to the Lord President's letter, one of the things that is stressed is the extended delays that could be expected in both criminal and civil cases, which is contrary to being trauma-informed and trauma-responsive. And with respect to the member, his party are frequently critical of the backlog of criminal court cases that we're still grappling with.
Rossa Finlay.
It's that phrase trauma-informed again, which I still don't know what it actually means. It seems to mean whatever the person using it wants it to mean. There's no actual definition of it. It can get bandied around to justify any action, or in this case, inaction. The Lord President, let me finish my point. The Lord President, of course, is in charge of the judiciary, and this amendment quite deliberately has sought not to meddle in his independence. This is about respecting what Victim Support Scotland and Scottish Women's Aid have said about the very real problem of the weaponisation of the criminal and civil courts by abusers. I'll give way.
Kevin Stewart.
I thank Mr Finlay for giving way. I'm quite surprised that Mr Finlay has said what he has about trauma-informed practice. Training is available in trauma-informed practice. Ministers have taken that training. Committee members, including the Social Justice Committee, have just completed that training. I think it would be wise, before anyone submits amendments on these issues, to take that training and learn what trauma-informed practice is all about.
Rossa Finlay.
Well, sitting in the Justice Committee for years, I tried my very best to get to the bottom of what the government meant when they talked about trauma-informed, and they could never, ever define it. If Kevin Stewart wants to enlighten all of us, I'd be delighted to hear it. I push the amendment or move the amendment in my name. Thank you.
Thank you, Mr Finlay. You're pressing the amendment. So the question is that Amendment 108 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division, and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 108 in the name of Russell Finlay is yes 27, no 80. There were 7 abstentions. The amendment is therefore not agreed. We now turn to Group 15, Special Measures, Civil Cases. I call Amendment 49 in the name of the Cabinet Secretary, grouped with Amendments 50, 51 and 52. I call on the Cabinet Secretary to move Amendment 49 and to speak to all amendments in the group. Cabinet Secretary.
Presiding Officer, the amendments in this group are technical and correcting. The bill lays down criteria on how a person is deemed to be a vulnerable witness in a civil case. At stage 2, amendments were agreed to add to those criteria to include people applying for a civil protection order or seeking damages for relevant behaviour, such as sexual assault or domestic abuse. When a person is deemed vulnerable, this generally flows through into the rest of the legislation. However, there is a presumption about when a personal conduct of a case should be prohibited, which makes specific reference to the criteria laid down for deeming a person vulnerable. As a result, this needs to be amended to reflect the changes made at stage 2, and Amendment 49 does that. Amendments 50, 51 and 52 correct a minor error contained within Stage 2 amendment where reference was made to the Children's Scotland Act 2020 and it should have been to the Vulnerable Witnesses Scotland Act 2004. Amendments 50, 51 and 52 correct that error, and I move Amendment 49.
Thank you, Cabinet Secretary. I note that no other member has sought to make a contribution in regard to this grouping, and I wonder whether the Cabinet Secretary has anything to add by way of wind-up.
No, thank you.
Thank you, Cabinet Secretary. So the question is that Amendment 49 be agreed to. Are we all agreed? Yes. The Parliament is agreed. I call Amendments 50, 51 and 52, all in the name of the Cabinet Secretary, and all previously debated. I invite the Cabinet Secretary to move Amendments 50 to 52 en bloc.
Moved en bloc.
Thank you. Does any member object to a single question being put on Amendments 50 to 52? I note that no member has objected, and therefore the question is that Amendments 50 to 52 are agreed to. Are we all agreed? Yes. The Parliament is agreed. I now call Amendment 53 in the name of Liam Kerr, already debated with Amendment 105. Liam Kerr to move or not move?
Moved.
Moved. The question is that Amendment 53 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. I always wonder for those who point of order, Cara Mochan.
Thank you. My app has gone blank. I just wanted to know if my vote had been recorded.
Thank you, Ms Mochan. Your vote has been recorded. Point of order, Brian Whittle.
So, Presiding Officer, my app froze. I would have voted yes.
Thank you, Mr Whittle. Your vote will be recorded. Thank you. The result of the vote on amendment number 53 in the name of Liam Kerr is yes, 42, no, 69. There were no abstentions. The amendment is therefore not agreed. We now turn to Group 16 on sexual offences court establishment. I call Amendment 109 in the name of Pauline McNeill, grouped with amendments as shown in the groupings, and I call on Pauline McNeill to move Amendment 109 and to speak to all amendments in the group. Ms McNeill.
Thank you. I move Amendment 109 in my name. I'll speak to 110, 111, 112, 113, 116, 117, 18, 19, 20, 21, 25, 26. These are all consequential ones, you can see. I'm sure I'm not going through them all. So, these amendments relate to the creation of a sexual offences court. So we all acknowledge the growth in the volume of sexual offence cases. At the last time we were notified, it was 69% of cases in the High Court are sexual offences. The Scottish Court and Tribunal Service said to the Criminal Justice Committee that the only realistic opportunity is to create a stand-alone court, but it isn't the only option, and my amendments deal with what I think is a more sensible option. I would like to say that I don't intend to move when I'm asked amendments 110 and 111. It was just a different way of doing it. So Amendment 109, as well as most of the amendments 112 to 160, allow the High Court to make the Sexual Offences Court a division within the High Court, but there would also be a Sexual Offences division within the Sheriff Court. Now, my understanding is that it would be the same number of courts, because you've got 9 locations that the High Court uses and 38 Sheriff courts. And of course, the High Court is a peripatetic court. It could extend those locations if it so wishes, and has done. As of the proposed Sexual Offences Court, there would be judges and counsel dedicated to dealing with sexual offences. It's important to note that High Court judges, probably based on these figures, deal with a high number of rape and sexual offence cases. So, to some degree, they are already specialists in what they do, but it's very important to note that rape cases will no longer be heard in the High Court as a result of the Government's proposals, but would be heard in the new Sexual Offences Court. And I'm sure you'll hear the Government talk about it's got the same sentencing powers, but let's be clear, it isn't the High Court. The highest court will still be the High Court of Justiciary, which currently operates at the moment. It could be trauma-informed. I don't believe we need legislation for trauma-informed. I think it could be done. However, the bill talks of trauma-informed throughout. A stand-alone court has created many problems that the Government had to go back and fix. One of the substantial ones they had to fix was the rights of audience. Not an insignificant matter. And it did prove to be quite a serious omission when the bill was written. And that means that the Government didn't consider who represented who. For example, senior advocates who represent people in the High Court wouldn't necessarily be in the Sexual Offences Court. However, the Government have corrected that. But we've just got to hope they've got that right and there aren't any gaps in it. My proposal would not require to fix that at all. I could have been persuaded. Yes, of course I will, yeah.
Nicola Sturgeon. We need the member's microphone. Has the member got her card with her? The member could collect a spare one and come in shortly.
I'm happy to come back to Nicola Sturgeon when I'm summing up, if she wishes.
Can I apologise, Presiding Officer, for omitting to put my card in? Can I thank Polly McNeill for taking the intervention? I wonder if she would acknowledge that it is the overwhelming view of survivors of sexual offences that a standalone specialist court would help reduce the compounding trauma that they're often subjected to in criminal proceedings under the current system. And as she progresses her argument, I wonder if she would address the question of how her amendments would address or effect the necessary culture change that many think is essential, and also how her amendments would address the delays that often bedevil the current system, because in the amendment she's laid, neither of these points are clear to me at this time.
Polly McNeill.
And that is the central question, because the evidence that the survivors to the committee talked about delay being the most concerning aspect of their poor experiences in the criminal justice system. And if we don't get delay down, we know that victims are going to continue to experience something that is unacceptable. And that is my primary concern. I'm going to go on to talk about this. And that is the creation of this standalone court, I think, is a big bureaucratic organisational change. And I am not convinced that that will get delayed down, and that is my primary worry. Otherwise, I might have been persuaded that is the best way to proceed. There won't be new sheriffs, for example. Can I just develop? Yeah, I will take it in a minute. So see, there won't be additional sheriffs. There will be the same number of sheriffs and the same number of judges. There's no suggestion that there were new judiciaries would be appointed. The Law Society supports the division of existing courts, i.e. my amendments, and they say we consider that the new court will create more complexity within the system, affecting the efficiency of criminal proceedings in cases of sexual offences. Whilst we appreciate the efforts made by the Scottish Government in addressing some of the concerns expressed at early stages, we are unconvinced that a stand-alone court is needed. We have expressed our support to the creation of specialist divisions within the current court structure, and we therefore support Amendments 109, consequential amendments in 112 and 160 introduced by myself. And to answer the other question that Nicola Sturgeon raises about the culture change, I am still arguing that yes, there should be a culture change, but creating specialist divisions within the existing court structures is the easiest and most efficient way of achieving that. I'm happy to give way to Rona Mackay.
Rona Mackay.
Thank you. I thank the member for taking the intervention. If the member would forgive me for quoting from last year's Labour manifesto, where it says, while structural change is important, transformational change within the court system will only come through changing culture and practice. The first step is to embed trauma-informed practices and procedures through our courts and justice system. To reduce court delays, Scottish Labour supports the proposal to establish a special sexual offences court. Now, I'm just curious to know why the change of heart.
Polly McNeill. Not a change of heart. What I'm arguing is that you can still get a specialism, trauma-informed practice. I'm going to go on and talk about some of the fundamental changes that I welcome the Government has made and the Lord Advocate that has contributed to that. So there is no contradiction in the Labour manifesto and what I'm arguing. I am simply saying that the structure should be the High Court, a specialist division of the High Court, and a specialist division of the Sheriff Court. And that's what I'm arguing today. Putting all solemn cases, sheriff and jury, which deal with sexual offences, including solemn cases currently heard in the Sheriff Court, into one court will create a very large court. So you need to be satisfied that in doing so that we actually are going to achieve a reduction and get those delays in the court proceedings reduced. And I think the volume of cases is potentially a problem here. Now, we've already heard that witnesses and victims can give their evidence by commission. And the Government has championed this, which I totally applaud. But this does not. So we've already taken steps to try and really change the court system. The rape myth that we talk about, that juries are told sign up to, is now part of the judge's direction to a jury. So we are already beginning to make incremental change within the system itself. The rule on corroboration has been changed, which affects all cases, not just sexual offences cases in particular. Trauma-informed practice can be applied to any court, and the bill, I don't think the bill currently requires the defence to do this, but we must have all practitioners. But it's very, very important when we are looking at how a court system actually begins to fit together, to address all the problems. And we know from debates in this Parliament that one of the big issues that's not been addressed is the number of defence practitioners who are leaving the profession. So if we don't address the gap that there is in relation to lawyers who are leaving the criminal bar, leaving the criminal profession, we won't be able to run any court, whether it's my proposal or the Government's proposal, without addressing that. Talk to any of the Law Society, the Scottish Bar Association will tell you that recent audits suggest that in the whole of Scotland we have 250 lawyers. Sheriffs sitting in the High Court as temporary judges are acting as High Court judges in all cases. Sheriffs appointed as judges in the sexual offences courts will be sheriffs exercising the powers of maximum sentencing. So there is a difference here, and it's important, whether you support the proposal or not, just to understand some of the structural changes and make some assessment of whether you think they're the right changes. There will be more sheriffs appointed to the Sexual Offences Court, but they won't be new ones. There won't be additional ones, but they will preside over cases. And it does slightly concern me that rape cases are going to be taken out of the High Court. And in another amendment, I will address the question of whether I think it's right that High Court judges shouldn't preside over rape cases, which they currently do at the moment. It does beg the question as well, and what does the High Court do if all these cases are taken out? But there wasn't really any examination. The committee, as I'm sure you hear in the debate tomorrow, such big fundamental issues that the committee had to wrestle with, and the Parliament's having to wrestle with now, removing the not proven verdict, the creation of a new court. There's a lot of fundamental reform in this, but we haven't really addressed what happens to the High Court if all of these cases are moved out. And it's maybe a minor issue, but still at the end of the day is something that we should have a chance to consider the impact. The new court will not be a new facility. It's not as if we're creating a new sexual offences court. It will be the same courts we already have. And I think it's important to note that there will be no new facility. It may be that under the government's proposal, that because sheriffs were interchangeable in rape cases, I would concede that you might be able to use more courts than under my proposal. But some of it will be limited by geography. The 38 courts that we have in the sheriff court system, you wouldn't use all of them because you wouldn't want a victim to have to go to Inverness if they were a victim of a crime in Glasgow. So there's still going to be limitations on what courts you could use. So crucially, I do think this should have been given much more consideration than it previously did. And if nothing else, I think it's really important to test whether or not this is, because it's going to be, there's a lot of resource going to be put in to making this quite a fundamental change. We have to make sure that it's right. But I think we're all committed to making that transformation and fundamental change, and I certainly am, Presiding Officer. Thank you.
Thank you, Ms McNeill. I now call Douglas Ross.
Thank you, Presiding Officer. I come at this series of amendments as a member who is not on the committee but has followed this issue with some interest, and I should refer members to my register of interest. My wife is a sergeant with Police Scotland. But I wanted to speak on this point because the Amendment 112 in Pauline McNeill's name is the same amendment that Russell Finlay put forward at stage 2, which was spoken to by my colleague Sharon Dowie. And on the face of it, I think when I listened to Nicola Sturgeon's intervention, if you suggest to people in the wider public that we're going to introduce a specialist court for sexual offences, that sounds like something that would garner support, that would be something positive. But when you start to look at the evidence that the committee took, and I have to say the responses from the Cabinet Secretary were quite dismissive of serious points made, be it about the costings in the financial memorandum, be it about some of the words of victims, which I will come on to in a moment, there are serious concerns about this. So we all want to see sexual offences treated extremely seriously, and justice for the victims, for offenders to be severely dealt with, and a better experience for victims. And I think what we have to determine tonight is the suggestion in Part 37 of this bill the right approach to take? Or does it sound like something that is positive, that we should support, but when you look at the detail, there are too many questions that remain unanswered. There are too many issues that are yet to be rectified, and that maybe we should look at making a specialist division of the High Court or the Sheriff Court as the option we look at now. I'm sure the Cabinet Secretary, in summing up, will use the same argument as she did at committee, that Lady Dorian, in her review, was suggesting that these specialist courts are the way forward. And if we don't take this opportunity, will there be people in the same room, the committee room where this was discussed, in 40 years' time making the same argument? But I would also look at that and say, what about in 40 years' time if we go down this route? If we make this massive change with so many questions around this, will there be people in 40 years' time saying, actually, the Scottish Parliament took the wrong decision? It didn't enact legislation in a way that does serve the victims of the most horrendous crimes. And that is the risk for me and the worry for me. And Pauline McNeill was right to say 69% of Crown Court, High Court cases at the moment are sexual offences at committee. Sharon Dowie made the point that this is an area of increasing problems within our society. Since 2020, the number of sexual crimes up by 11%, rape and attempted rape up 25%, sexual assault up 15%. These are horrendous crimes, and they are becoming more common. More victims are suffering as a result of this. Therefore, we have to ensure for them that the justice system is working. But there are so many elements of this where victims are speaking out, raising their concerns. Yes, it sounds like a positive proposal, but actually the detail in this bill, in this element of the legislation, may actually cause more problems. I think Pauline McNeill was right to speak about the High Court, the highest court in our land, established under the Scotland Act of 1998, and it has a status. When a crime goes to the High Court, people know that is the most severe crime. And I thought it was interesting that at the committee sessions on the 17th of January 2024, victims of crime, survivors of crime, were raising concerns about the status of their crime, what they had gone through, if it didn't go to High Court. Rape survivor Sarah Ashby said, "I would not like for such cases to be diminished or for us to be made to feel that they are any less significant than they are. When you get the information through that the trial is going to the High Court, there is an element of realising how important that is." And another rape survivor, Ellie Wilson, told the committee, "Rape is one of the most serious crimes in Scots law. Such cases are only ever heard in the High Court. That solemnity is sacred, and it is important that we maintain it." So I think when the victims are telling us that, when they come to a committee of this Parliament to raise these concerns, there is an obligation on us to listen to them. So yes, I know there will be arguments from the Cabinet Secretary that there are others in support of this proposal. I think everyone would be in support of that general idea of a specialist court. But if it is simply changing the name on a door, if it is basically window dressing, not my words but the words of Simon de Rollo KC, who said there is a danger that creating a specialist court would just be a bit of window dressing, then I do not think this is the right approach to take. I don't think this is the right approach to spend, I think, £1.4 million on, when we could use that money and resources to better support our victims through the current system and see if there are other changes that could be made, rather than a fundamental change that has not brought victims with them. So I hope, in considering what Pauline McNeill has put forward at stage 3, what Russell Finlay and the Scottish Conservatives put forward at stage 2, the Government could, even at this late stage, recognise that while the intention may be good and valid, the reality is this may end up failing victims, and that is not what any of us would like to see, and that's why I will support the Amendment 112 to hopefully remove Section 37 from this bill. Thank you, Presiding Officer.
Thank you, Mr Ross. And I call the Cabinet Secretary.
Presiding Officer, I do have a lot to say about the amendments in this group, and I can, however, assure Parliament that what I have to say is important and relates to the amendments in this group and also in Group 17. Ms McNeill's amendments, in my view, are a licence to do nothing. Her amendments only give the High Court the power to establish specialist divisions. They put no obligation, and therefore they are no guarantee of action or indeed of being implemented. The creation of the Sexual Offences Court is a key reform in this bill, which has been shaped by the voices of victims, survivors and their families. We know that victims of sexual offences require additional support throughout their interactions with the court system. A standalone national specialist sexual offences court will respond more appropriately to the unique needs of victims in these cases, while continuing to protect the rights of the accused. The court will embed specialist approaches to the way these cases are managed and the way complainants are treated. It will drive reform of practice, process, culture and increase efficiency and effectiveness, reducing the number and frequency of unnecessary court adjournments and ensuring that cases reach trial more quickly. Presiding Officer, I would have liked the support of all of this Parliament for the creation of Sexual Offences Court, which is backed by victims and their support organisations and leading members in the justice system. They've been clear that this court can deliver future improvements in culture, process and practice. However, despite that strong backing, reaching collective consensus across Parliament has not been possible. And this is a disappointment to me, as it will be to victims, because we must, as a Parliament, recognise the opportunity we have in establishing this new Sexual Offences Court. We must design it with the jurisdiction and judiciary for it to succeed in delivering meaningful and sustained change for victims. The status quo is not an option. That is why I cannot support any of Polly McNeill's amendments, either in this group or the next, which are symptomatic of thinking that prioritises hierarchies, status and tradition over progressive and practical solutions that will improve the experiences of complainers in sexual offence cases. These are cases that, as MSPs, we hear about regularly in our casework, just as we hear about high-profile cases at the centre of many campaigns backing the creation of this specialist court. Presiding Officer, the amendments in this group and the next present this Parliament with a choice about how it proceeds with the creation of a specialist court that works for victims. Polly McNeill has suggested that we abandon plans for a distinct sexual offences court that has been developed over years with victims and partners, and instead pursue specialist divisions of the High Court and Sheriff Courts, a proposal which has been resoundingly rejected by virtually every senior figure in the criminal justice system. And if, for a moment... OK, yes.
Ms Ross.
I'm grateful to the Cabinet Secretary for giving way. Just on that point then, why does she believe the Faculty of Advocates say faculty considers that there is no single feature of the proposed court which could not be delivered rapidly by introducing specialism to the existing High Court and Sheriff Court structures? Are the faculty wrong?
Cabinet Secretary.
In this instance, I do believe the Faculty of Advocates are wrong, and if I can, if I may quote Lady Dorian, when, in response to a question from the convener of the Criminal Justice Committee asking if her review group had considered specialist divisions, and Lady Dorian said, in our view, although the review group was not unanimous on everything, it was unanimous on this. And that was that an approach was necessary that would go beyond tinkering and creating a little specialist group within the overall judiciary. We felt strongly that simply creating another division of the High Court, for example, would not achieve the necessary end. What was needed was a court of full national jurisdiction with trauma-informed practices embedded, common training of individuals across the court, procedures that are uniformly applicable to the Sheriff Court and the Court of Session, which is not currently the case, and uniformly applicable practice, notes and directions, which again is not currently the case. High Court directions apply only to the High Court, whereas the Sheriff Court and the Sheriff Principals in each sheriffdom are responsible for issuing directions in that sheriffdom. Unfortunately, applicable procedures, expectations and case management with uniformity from Dumfries to Wick is therefore required. We want consistency of treatment for all victims of sexual crime. Presiding Officer, the amendments in this group, as I've said, present us with a choice. And fundamentally, the case for establishment of a specialist divisions within the High Court has, in my view, been resoundingly rejected. The establishment of specialist divisions of existing courts is little more than a continuation of the iterative piecemeal approaches of the past, which, despite the best intentions, have just not delivered meaningful improvements to the experience of sexual offence victims. And as Lady Doreen set out, those who work within the criminal justice system have learnt from experience the shortcomings of seeking to introduce changes to the management of sexual offence cases within the confines of existing court structures. If we in this Parliament fail to heed that experience, then it will be the victims of sexual offences who fail to see the improvements that we all agree are needed. Presiding Officer, Ms McNeill herself has recognised that specialism is needed, and if that is the case, then surely she must agree that we need an approach that we can be confident will actually be effective at embedding specialism. Creating divisions of existing courts is not an effective way to do that. Indeed, arguably, the High Court already has the power it needs to create divisions, yet it has not considered that appropriate or sufficient to deliver the changes needed. Judicial specialism develops when cases of a particular type are considered together in a single forum, enhanced by bespoke training, practice and rules. This has been the experience across different jurisdictions and areas of law. The larger the pool of cases, the greater the opportunity for the procedures and processes intended to streamline the management of these cases and to the better to support victims. Distributing sexual offence cases across a diffuse structure of numerous specialist divisions will blunt the capacity to develop best practice and also create additional complexity and bureaucracy. Perhaps more importantly, divisions would make it all but impossible to apply specialist approaches in a consistent way across all sexual offence cases. To ensure national coverage, 7 different specialist divisions, 1 in the High Court and 1 in each of the 6 sheriffdoms, would be needed to be created. These 7 divisions would each have distinct processes, procedures and ways of operating that would add significant complexity and confusion to the existing system. By contrast, Presiding Officer, the proposal for a standalone sexual offences court emerged from a judicially led review into how the management of sexual offence cases could be improved to better support victims and enjoys strong support from senior figures across the justice system. Those who work within the criminal justice system and victims with lived experience recognise that what is required is a complete rewiring of the way in which sexual offence cases are managed. This requires us to move out of the confines of tradition, and it's perhaps an uncomfortable truth, particularly for those who have dedicated their professional lives to our criminal justice system and who care deeply about the issues that we are talking about today. But the hierarchy and the tradition woven through our system is not delivering for victims, and we need systemic reform which will enable us to build a new culture, processes, procedures from the ground up. We need to embrace this opportunity and equip the court with the building blocks it needs to succeed. And that is through the jurisdiction, the judiciary and the sentencing powers that this bill will endow it with. While changes such as the requirement for trauma-informed training and the presumption that victims will be able to pre-record their evidence will introduce immediate benefits for how these cases are managed, the creation of a standalone sexual offences court is just the start of the journey. The real benefits of creating a standalone court lie in its role as a platform for change, one that fosters a culture that is not about status or tradition, but rather about identifying and adopting progressive and humane approaches to the management of sexual offences that are created and centred on the needs of victims. This is something that everyone in this Parliament should be able to get behind. And, Presiding Officer, let me be clear, there is no downgrading here. Quite the contrary, the court is a recognition of the particular care and attention that these cases demand. The bill will deliver a court that will be able to utilise the combined court and judicial resources of both the High Court and Sheriff Courts. Not only will this allow the Sexual Offences Court to call on the wealth of skills and experience that exists among the judiciary across these courts, it will also ensure that the entirety of the court estate can be used to hear sexual offence cases. And the High Court currently sits in 9 locations and the Sheriff Court at 39, the Sexual Offences Court will have access to all of those locations, enabling more capacity for trials to be scheduled, while also doing so in a way that supports delivery of local justice. Presiding Officer, this will be a huge benefit to victims by supporting their cases to reach trial more quickly, possibly be closer for them to travel to, and will ensure that we have a sustainable model for the management of sexual offence cases. There is a necessity for a number of reasons, not least because there continues to be growth in the number and complexity of these cases as more women have faith in our justice system and report cases. We know that for years women just did not report sexual offences. They stayed hidden due to stigma, shame and lack of faith in the justice system, from reporting to court conclusion. Presiding Officer, we have seen a shift due to changes over decades in culture, legislation and attitude, but we need to support those who come forward, just as we need to continue to tackle all the underlying causes of abuse and violence against women and girls. And as campaigners have said, it is the perpetrator of these offences who should feel the real shame and not the victim. Presiding Officer, I want to see the creation of a sexual offences court that works, so I urge everyone in this chamber to reject Ms McNeill's amendments in Groups 16 and 17 and back the bill.
Thank you. I now call on Polly McNeill to wind up. Press to withdraw Amendment 109. Ms McNeill.
Let me begin by saying that I think I've demonstrated in this Parliament that I share the Cabinet Secretary's last comments about how the system has failed women and girls and how much work we have to do. What we are debating now is whether the Government's proposal for a standalone sexual offences court will do all that they claim that it's going to do, and that it is the only way and the best way. That's what we're debating here. We are not standing still already. I mean, we've already discussed the giving evidence by commission. The current Lord Advocate has done more in my career to look after victims who've given evidence to the Justice Committee, who say that it's the only Lord Advocate under which they've been able to sit down with their advocate and talk about their case. And I'd argue that that should be a statutory requirement, a single point of contact. These are all the things that victims talk about, how they don't get told about their cases, how they don't get told or to talk to their advocate deputy. So change is already happening regardless of whether we pass the bill or not. But the question is, there is no guarantee that all of this will work. The unique emphasis on embedded trauma and I agree with this wholeheartedly, but it isn't the only way that it can be done. Reducing court adjournments, I didn't fully understand why this proposal would reduce court adjournments, that you couldn't, because we're always reforming the court system. And it is unfair to say that we would be supporting the status quo, because the status quo is already changing for the reasons I have said already. I don't think the Government have demonstrated how delay. They've made a series of statements, right, of ambitions, but nothing concrete about how they're actually going to reduce delay, and I don't think they have demonstrated that. I do agree that it's important that there is consistency of treatment for victims, but I just don't really see how this is the only way to achieve it. Now, I fully accept that you change the structure of the way that you do things, that maybe that's one way forward, but the idea that you don't lose something is, I think, has got to be acknowledged, because rape is one of the most serious crimes that can be committed, and it will no longer be heard in the High Court of Justiciary. It would be heard in the Sexual Offences Court. But that's an argument that perhaps you believe that reducing delay is something that would compensate for that. So I don't accept the Government have really demonstrated all of this that they claim. If there are 9 locations of the High Court, and my proposal that would create a specialist division, those 9 locations are available for a specialist court. If there's a specialist division of the Sheriff Court, then there's 38 Sheriff Courts that can be used. So I don't really see what the Government are arguing here, that somehow under my proposal there are less locations. I have considered already the differences you would use sheriffs, and that's not included in my proposal. I conclude, Presiding Officer, by saying I'm going to push my Amendment 109 because It does have the support of the Faculty of Advocates, and it does have the... You know, we're not all agreeing on everything here, but to suggest that there aren't some legal minds that do actually think this is the best way. And I finish on this. My real worry about this court is that we're going to spend so much time and resource on a bureaucratic change that I just worry that that in itself will mean that we won't get delay down. And the question of the practitioners has not been addressed by the government, and that is, and I'll finish on that, sorry. I'm finishing.
Okay, the question is that Amendment 109 we agreed to. Are we all agreed? No. Parliament is not agreed. There will be a division and members should cast their votes now. And the vote is now closed. Okay, the result of the vote on amendment number 109 in the name of Pauline McNeill is yes 45, no 66. There were no abstentions. The amendment is therefore not agreed. Call amendment 110 in the name of Pauline McNeill, already debated with amendment 109. Pauline McNeill to move or not move?
Not moved.
That is not moved. I call amendment 111 in the name of Pauline McNeill, already debated with amendment 109. Pauline McNeill to move or not move?
Not moved.
That is not moved. I call amendment 112 in the name of Pauline McNeill, already debated with amendment 109. Pauline McNeill to move or not move?
Not moved, and if it's helpful, Presiding Officer, I don't intend to move any of the consequential ones.
We'll probably come to that, Ms McNeill. We're coming up to Group 17 shortly anyway. I call amendment 113 in the name of Pauline McNeill, already debated with amendment 109. Pauline McNeill to move or not move?
Not moved.
That is not moved. Members will note that we have passed the agreed time limit for the debate for this group to finish. I've exercised my power under Rule 9.8.4a subsection C to allow the debate on this group to continue beyond the limit in order to avoid the debate being unreasonably curtailed. We move to Group 17, Sexual Offences Courts, Jurisdiction, Judges and Organisation of Business. I call Amendment 114 in the name of Pauline McNeill, grouped with other amendments shown in the groupings. Pauline McNeill to move Amendment 114 and speak to all other amendments in the group. Ms McNeill.
Thank you. Amendment 114 ensures that the crime of murder may not be heard in the Sexual Offences Court. The Law Society said in Amendment 114 in the name of myself maintains the jurisdiction of the High Court of Justiciary for the charges of murder, and we consider this as a sensible approach if a standalone court is introduced, and we are supportive of this amendment. But the Senators of the College of Justice said that murder should only ever be tried in the High Court, and the anecdotal nature of paragraph 280 in the policy memorandum gives no confidence that this major constitutional change has been thought through properly. The policy memorandum says that paragraph 280 that there are known cases in which sexual abuse perpetrated by an accused is alleged to have escalated over time against multiple complainers, ultimately leading to a murder, and that given the experience of the surviving complainers and the nature of their evidence, the policy objective is to afford them the benefits of the case being prosecuted in the Sexual Offences Court. They say that while this is undoubtedly true, there are not many such cases, and the anecdotal nature of paragraph 280 gives no confidence that this major constitutional change has been thought through properly. They say the appropriate place for the charge of murder and attempted murder is the High Court. Murder is the most serious charge in the criminal canon, and it is that charge which should determine the forum. The suggested change ignores the fact that in very few cases where sexual offences are alleged against the surviving complainer, it is likely that the case will be tried before a judge who is also a judge of the Sexual Offences Court, and that most, if not all, of the benefits of that court will be able to be afforded to such a complainer. We remain firmly of the view that life imprisonment and orders for lifelong restriction should be the exclusive province of the High Court. Amendment 115 has the effect of ensuring that only a judge from the High Court or the Lord Justice General or the Lord Justice Clerk can try a case which involves the offence of rape. The Law Society again has expressed support for this amendment. They say we also consider it appropriate that when a charge of rape is tried before the Sexual Offences Court, that at least one of the judges should hold a relevant high judicial office. This seems to be consistent with Section 3(6) of the 95 Act. Amendment 123 ensures that the President of the Sexual Offences Court must prepare a plan that makes sure that the new court is operating efficiently. That plan must also be kept under review and revised where necessary. And part of the rationale given by Lady Doreen for recommending the creation of a specialist court was to ensure that cases would be disposed of more quickly than is currently the case. Lady Doreen said the court was essential to meet the increased workload in sexual offence cases, as the number had risen dramatically in recent years. And I'd expressed my concern about whether or not the new Sexual Offences Court can, in fact, reduce delay by simply saying that it will. And so I hope the Government give due consideration to the fact there should be some plan so we can see set out should this come to pass. Amendment 127 is a consequential amendment that removes the offences of murder and attempted murder from this part of the bill, which sets out that solicitors have the rights of audiences, because it's no longer required as it now is. And that's all I have to say. Thank you.
Thank you. And I call the Cabinet Secretary to speak to Amendment 88 and other amendments in the group. Cabinet Secretary.
Thank you, Presiding Officer. I said in the last group what I wanted to on the creation of a Sexual Offences Court and my opposition to Ms McNeill's amendments in both this group and the previous one. But I will take this opportunity to provide some specifics. The status of our institutions or those who work in them does not protect victims from unnecessary re-traumatisation. What victims need is for their cases to be heard by judges who are capable of embedding specialist trauma-informed approaches. Those judges include sheriffs and sheriff principals who have a wealth of skills and experience. Lady Doreen recognised in the review that underpins this court that allowing specially trained sheriffs to hear rape cases would unlock both skill and capacity to the benefit of victims. It is a core aspect of the model she set out and reflects that currently many sheriffs are appointed as temporary judges and are hearing these cases now. Specialist approaches must be applied consistently to all victims of sexual offences, regardless of what other offences are included on the indictment, and that includes murder. There have been some deeply troubling cases in Scotland in which multiple surviving victims of rape and sexual abuse are called to give evidence in cases where the accused offending has escalated to murder. Those victims' needs are the same as others, and they deserve to be able to access this court and benefit from the specialist trauma-informed environment it will provide. I therefore oppose Amendment 114 on grounds of principle, but I would also note that the way it interacts with Amendment 127 would mean that whilst only murder was removed from the jurisdiction of the court, both murder and attempted murder would be removed from the category of cases in which an accused must be represented by counsel. That would mean that an important measure that we introduced at stage 2 to offer accused certainty that if prosecuted in the Sexual Offences Court for attempted murder, they would, as a matter of law, be entitled to be represented by counsel, and that would be lost. I also oppose Amendment 123 on the grounds that it is unnecessary and will contribute nothing to the effective functioning of the court. I recognise that the member has concerns about the size of the caseload and how the volume of cases indicted to the court will be appropriately managed. However, the caseload will not be an outlier compared to other criminal courts. It is also important to note that the new court will not create new cases. It will simply redistribute the cases we have more efficiently and to a wider number of locations, making access in the court easier for all. And I therefore urge Parliament to reject all of Pauline McNeill's amendments. Presiding Officer, turning to my own amendments in this group, it is on the shoulders of those judges who are appointed to preside over cases in the Sexual Offences Court, above all else, that the success of the court will ultimately rest. They will have the power to embed the specialist trauma-informed approaches that will be so crucial to improving the management of sexual offence cases. Given the vital importance of their role, we must make absolutely sure that the legislative process in place for appointing judges to the court are appropriate and effective in delivering the pool of experienced and specialist judges required. During Stage 2, I highlighted the need to strike a balance between rigour and proportionality in these appointments, but also signalled that I would keep this under review. Having had the opportunity to reflect and engage further on these issues, including with the Lord Justice General, I now consider that further adjustments are needed to avoid unintended consequences. As I have discussed with opposition spokespeople and set out in my letter to the Criminal Justice Committee sent in advance of Stage 3, there is a concern of the lack of flexibility inherent in a process that requires sheriffs and sheriff principals to be appointed as judges of this court by Scottish ministers. On reflection, I feel that some of the amendments to the processes made at Stage 2 tend towards an approach which is too rigid and overly cumbersome. Instead, what is needed is an appointments process that enables the Lord Justice General to identify and deploy to the court those who possess the skills and experience necessary to progress the change in culture, practice and procedure that will be so important. Accordingly, Amendments 89 to 92 in this group would remove responsibility for appointing sheriffs and sheriff principal to the office of Judge of the Sexual Offences Court from Scottish ministers and return the power to Lord Justice General. Yes.
Grateful. At Stage 2, of course, it was the Government who changed the original bill to say that ministers would appoint these judges rather than the Lord Justice General. Now, Cabinet Secretary will remember that I raised this at Stage 2 and suggested that it might be a power grab, but my concern was dismissed. The Cabinet Secretary told me it was necessary and in line with the committee's recommendation. However, it now appears that I was right. And I should say, and I want to put on record, that I respect the willingness to reconsider and come to a different view. But ask the Cabinet Secretary this: does she agree that this process shows the benefit of being able to debate substantive amendments such as these at all stages of the legislative process? And it will rarely be, if ever, a good idea to bring in substantive, significant amendments at Stage 3 which have far-reaching consequences and don't have the benefit of this full process that she's talking about.
Cabinet Secretary.
Yes, Presiding Officer, I do of course agree with the importance of scrutiny and debate that tests all propositions, but just if I could perhaps as a matter of record, what I did clearly say to Mr Kerr during Stage 2 was that I would continue to keep this matter under review given the importance of it. And I wasn't sure how serious he was about his question at committee about a power grab, but as he is clearly concerned about that, I'm sure the amendments today will allay his fears. Collectively, Presiding Officer, Amendments 89 to 92 would revert the position in relation to the appointment of sheriffs and sheriff principals as judges in this court back to that set out in the bill at introduction, with one exception, being that the appointment must be for a period of 5 years, and this takes account of earlier concerns raised about security of tenure for judges of the Sexual Offences Court. As well as streamlining the appointments process, I have also brought forward Amendment 88, intended to expand the pool of judicial resource from which the Lord Justice General can draw when making appointments to the court to include eligible former senators. Former senators have a wealth of experience in the management of sexual offence cases, and in my view, the court should be able to access this experience. Finally, Presiding Officer, Amendment 93 in my name is a technical amendment which adds High Court judges and temporary judges to the list in section 41(8) so that they would also be automatically suspended from the office of President or Vice President if they were suspended from their substantive judicial role. I urge Parliament to support my amendments in this group and reject those of Pauline McNeill.
Thank you. And I call on Pauline McNeill to wind up. Press to withdraw Amendment 114. Ms McNeill.
I don't have much to add. There's just one point I wanted to make in relation to the appointment of sheriffs. I think it's important to note there is a distinction, however you view it, that temporary sheriffs appointed to the High Court sit as High Court judges and they'll sit in rape cases and murder cases. But sheriffs appointed to the new Sexual Offences Court won't be sitting as High Court judges, so if they sit in a rape case, they'll be sitting as a sheriff. Now, I'm not saying, I was just pointing out that there is a difference. It's not the same. It was the senators of the College of Justice that raised the question of where murder should be tried, and it was their view that murder should continue to be tried as the most serious offence in the highest court of judiciary. And I still have some concerns about completely taking down the system that has served some purpose for reasons I'm not really too clear about, and that's what the senators point out. That there's really, why would you do it? It's not really going to be used. However, the government have set their arguments against it. With that, Presiding Officer, I conclude and I move my amendment.
The question is that Amendment 114 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. The vote is now closed. The result of the vote on Amendment 114 in the name of Pauline McNeill is yes 47, no 65. There were no abstentions. The amendment therefore is not agreed. I call Amendment 115 in the name of Pauline McNeill, already debated with Amendment 114. Pauline McNeill, to move or not move?
Moved.
The question is that Amendment 115 be agreed to. Are we all agreed? Parliament's not agreed. There will be division. The members should cast their votes now. And the vote is now closed. And the result of the vote on amendment number 115 in the name of Polly McNeill is yes 46, no 65. There were no abstentions. The amendment is therefore not agreed. Call amendment 116 in the name of Polly McNeill, already debated with amendment 109. Polly McNeill to move or not move?
Not moved.
That is not moved. I call amendment 117 in the name of Polly McNeill, already debated with amendment 109. Polly McNeill to move or not move?
Not moved.
That is not moved. I call amendment 88, 89, 90, 91 and 92, all in the name of the Cabinet Secretary, all previously debated. I invite the Cabinet Secretary to move amendments 88 to 92 on block. Cabinet Secretary.
On block.
Does any member object to a single question being put on amendments 88 to 92? The question is that amendments 88 to 92 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call amendment 118 in the name of Polly McNeill, already debated with amendment 109. Polly McNeill to move or not move? That is not moved. I call amendment 119 in the name of Polly McNeill, already debated with amendment 109.
Not moved.
That is not moved. I call amendment 93 in the name of the Cabinet Secretary, already debated with amendment 114. Cabinet Secretary to move formally.
Moved.
The question is that amendment 93 be agreed to. Are we all agreed? Parliament's agreed. I call amendment 120 in the name of Pauline McNeill, already debated with amendment 109. Pauline McNeill to move.
Not moved.
That is not moved. Call amendment 121 in the name of Pauline McNeill, already debated with amendment 109. Pauline McNeill to move.
Not moved.
Not moved. I call amendment 122 in the name of Pauline McNeill, already debated with amendment 109. It's not moved. Call amendment 123 in the name of Polly McNeill, already debated with amendment 114. Moved or not?
Not moved.
That is not moved. Call amendment 124 in the name of Polly McNeill, already debated with amendment 109. Polly McNeill to move or not move?
Not moved.
It's not moved. I call amendment 125 in the name of Polly McNeill, already debated with amendment 109. Move or not move?
Not moved.
That is not moved. Call amendment 126 in the name of Polly McNeill, already debated with amendment 109. Polly McNeill to move or not?
Not moved.
It's not moved. I call amendment 127 in the name of Polly McNeill, already debated with amendment 114. Polly McNeill to move or not move?
Not moved.
That is not moved. I call amendments 128, 129, 130, 131, 132, 133, 134, 135, 136, 137, 138, 139, 140, 141, 142, 143, 144, 145 and 146, all in the name of Pauline McNeill, all previously debated. I invite Pauline McNeill to move amendments 128 to 146 on block.
Not moved.
Pauline McNeill has indicated that she is not moving amendments 128 to 146. It would be helpful if any member wishes to move any of the amendments 128 to 146 could indicate now. I see no member has indicated they wish to do so. I therefore intend to read out the amendment numbers and confirm that they are not moved. I will do so at a pace that would allow any member to call out at the relevant point that they wish to move the amendment. So I confirm for the record that the following amendments in the name of Pauline McNeill are not moved. 128, 129, 130, 131, 132, 133, 134, 135, 136, 137, 138, 139, 140, 141, 142, 143, 144, 145 and 146. We now move to Group 18, Special Measures in Criminal Cases. I call Amendment 54 in the name of the Cabinet Secretary, group with Amendment 163. Cabinet Secretary to move Amendment 54 and speak to both amendments in the group. Cabinet Secretary.
Presiding Officer, Amendment 54 relates to changes I made at Stage 2 about how the pre-recording of evidence of child witnesses operates in the Sexual Offences Court, and also how it currently operates in other courts under the Criminal Procedure Scotland Act 1995. Those changes remove the distinction drawn between children aged under 12 and children aged 12 or over to enable the court to give due weight to the views of all children about how they would prefer to give their evidence, both in the Sexual Offences Court and in other criminal courts. However, reference to the distinction remains in Section 271E of the 1995 Act, albeit it is compatible with the UN Convention on the Rights of the Child, because it doesn't prevent the court from having due regard to the views of children under 12. Nevertheless, our broader policy position is that we should move away from the presumptions that children of a certain age or older are able to form a view about how they wish to give evidence. Amendment 54 therefore removes this presumption whilst maintaining the provision within Section 271E which allows for a parent or guardian of a child witness to give views about how their child should give evidence. The overall effect of Amendment 54 is to allow the court to give appropriate consideration to the views of child witnesses and their parents or guardians based on the circumstances of the case and the best interest of the child. Amendment 163 is a related amendment which makes the relevant changes to the long title of the bill, and I move Amendment 54.
Thank you. No other members that have asked to speak. Cabinet Secretary, anything to add by way of wind-up?
No, thank you.
Okay, the question is that Amendment 54 be agreed. Are we all agreed? Parliament is agreed. We move to Group 19, Independent Legal Representation. I call Amendment 55 in the name of the Cabinet Secretary. Group with Amendments 56 and 57. Cabinet Secretary to move Amendment 55 and speak to the other amendments in the please.
Presiding Officer, Amendment 55 is a response to a gap which I believe should be covered by the restrictions in Section 274 of the Criminal Procedure Scotland Act. These restrictions prohibit the leading of evidence which relates to the sexual history or character of complainers in sexual offence cases. These protections can be removed though when certain conditions are met, and it is for the court to decide when that may be permitted by applying the statutory test contained in Section 27A of the 1995 Act. I am conscious that there was media interest over the weekend about these amendments, and I want to address some of the issues raised to ensure Parliament is clear on the actual effect of what is proposed. I also want to make clear that the Section 274-275 regime in its current form has been in place for 23 years, and the European Court of Human Rights has expressly approved them and stated that they were capable of being applied in a manner which is compatible with the accused's right to a fair trial. Nothing we can do here should look to unpick those protections, nor equally fairness to the accused. Turning to the detail of the amendments, Amendment 55 extends Section 274 protections firstly to docket witnesses. A docket can be added by the prosecutor to an indictment or complaint when it is necessary for the prosecutor to lead evidence of criminal conduct, but it is not competent to libel a charge detailing that conduct. This might be, for example, because the offence is time-barred or the accused has already been tried for the behaviour. And I must stress that an accused cannot be convicted on any conduct contained in a docket, but the evidence led in relation to that conduct can provide corroboration for the charges of the indictment or complaint. Amendment 55 will ensure that the restrictions in Section 274 will also apply to witnesses who are given evidence in relation to an act or omission on a docket where that act or omission could amount to a sexual offence. This means that they will be given the same protection as given to complainers. I absolutely agree that fairness to all parties is essential. That is why the right to Section 274 protections comes with the associated statutory right for the accused or prosecutor to ask the court that the evidence be admitted under Section 275. The second element of Amendment 55 seeks to extend the restrictions in Section 274 to cover complainers in all cases which involve offences under Section 1 of the Domestic Abuse Scotland Act 2018, which introduced the new offence of abusive behaviour towards a partner, where the course of behaviour includes behaviour which could amount to a sexual offence. The current law requires the prosecutor to satisfy the court that there is a substantial sexual element contained in the charge for the restrictions to apply. I consider that the intimate nature of the relationship between the accused and the complainer, together with the vulnerabilities associated with coercive control, mean that the restrictions should apply to all such complainers when they are giving evidence about behaviour that could amount to a sexual offence. Amendment 55 provides certainty and reassurance to these complainers about the protections that they can expect and means that the prosecutor does not have to seek an order from the court before the restrictions are deemed to apply. As with docket witnesses, the accused and prosecutor will have the right under 275 to apply for the evidence to be admitted during the trial, that the decision lies with the court. As the right to independent legal representation is linked to applications under 275, these groups of witnesses and complainers will be entitled to independent legal representation. Amendments 56 and 57 are two vital correcting amendments relating to deceased complainers. They address an unintended consequence of an amendment that was agreed at stage 2, during which I set out our position on deceased complainers and access to independent legal representation. Section 274 protections already apply to deceased complainers under the current law, as is necessary in cases where a woman is raped or murdered, for example. However, at stage 2, we lodged an amendment to change the definition of complainer at section 275 to make it clear that the right to ILR does not apply to the complainer if they are deceased. In doing so, we inadvertently removed the right of the accused and the prosecutor to make an application to lead evidence of a deceased complainer's sexual history or character. The purpose of Amendments 56 and 57 is to reinstate the fundamental balance afforded by Section 275 to ensure that proceedings continue to be fair and that an accused is able to make an application under Section 275 where they consider this is necessary. I therefore call on members to support these amendments, which do not alter the current law and how Sections 275 and 274 apply to deceased complainers, but ensure that the accused continues to have access to their rights under Section 275 in these cases. And I move amendments 55, 56 and 57 in my name.
Thank you. Call Liam Kerr.
Thank you, Presiding Officer. I rise to speak to, but neither for nor against at this stage, Amendment 55. In doing so, I remind the Chamber that I am a practising solicitor and I am registered with the Law Society of Scotland. At the outset, let me once again express my significant disquiet with the increasingly blurred distinctions between each stage of the legislative process in this, our unicameral Parliament. Presiding Officer, this bill was first laid in April 2023. Stage 1, the principles of the legislation were voted on the 23rd of April 2024. There then followed extensive rewriting of the bill, many representations from expert groups, further committee evidence sessions and a long, detailed, intense and I dare say very constructive Stage 2 process. Stage 3 is the stage at which this Parliament votes to pass or not pass a bill. There is scope to amend, but because we are a unicameral Parliament with no revising second chamber or any scope to address unintended consequences post-Stage 3, it is very important that matters which make fundamental changes should not be introduced prior to Stage 3, especially where there's been zero discussion of it in any of the previous stages. Yet here we are, looking at Amendment 55, which was introduced on the 4th of September and seeks to make a fundamental and decisive change to a 30-year-old Act. And it will do so based on this debate today. A debate in which the government backbenchers will have been whipped to support it, regardless of what I or anyone else in this chamber says. Now, against that background, let me make clear, I completely understand what the Cabinet Secretary seeks to do here, the principle of the amendment. I totally understand why this is so important to groups such as Victim Support Scotland, who argue it will give complainers in these cases more consistent protection. But I also note that in the very restricted time available to consider such a far-reaching amendment. The President of the Scottish Solicitors Bar Association came out at the weekend saying the impact of this amendment is far from closing a loophole or a gap, as the Cabinet Secretary styled it. It's potentially extremely prejudicial in terms of the strengths of the evidence led, the inability to cross-examine, and could potentially have the opposite effect to that which is intended by the amendment. Now, we then received a significant note from the Law Society just yesterday, reiterating my point about process, suggesting that if the Cabinet Secretary wanted to expand the scope of Section 274, the one amended by Amendment 55 today, it should have been done at earlier stages, ensuring a proper and informed debate. They go on to suggest that Amendment 55 may fundamentally change the evidential picture in a large number of cases where there is no sexual element. I will take an intervention.
I'm very grateful. I'm listening very carefully to the comments made by the member, who clearly has far more legal understanding than I do. But I'm concerned by those two particular interventions that have been made by external partners about this particular amendment, Amendment 55, but also by the sheer volume of communication I've had from members of the public who, at least, if nothing else, believe that there is a perception that this will water down rights. The quote that we've all been sent, which we've had repeatedly, is that these changes would mean that juries could be asked to convict on a basis of untested and unchallengeable evidence. The problem is I do not know whether that is true or not, yet we're being asked to make a decision in a short few minutes. I wonder if the government could find other means of introducing changes such as this outside of the realms of this bill, perhaps, that would make it open to more scrutiny by the Justice Committee.
Grateful. Jamie Green has actually predicted my intervention on the Cabinet Secretary's closing precisely because he's absolutely right. We have received a lot of representations raising concerns with this amendment. Equally, it falls to be considered that we have received a lot of interventions, a lot of communication saying why people are in favour. And we have to balance that up. And we have to do that on an amendment that was only laid and was only put before us less than 2 weeks ago. And the other thing that I think Jamie Green particularly may wish to consider is that the Law Society and the Faculty of Advocates have raised issues around the sections amended by this Amendment 55, because in the case of Keir and Daly versus HMA is a case on which the Supreme Court has yet to issue judgment, but which may directly impact the interpretation of sections 274 and 275, which are sought to be amended by Amendment 55 today. They suggest, the Law Society and the Faculty of Advocates suggest, that to legislate now on something that the Supreme Court will shortly rule on would be less than prudent. Look, I want to reiterate, we completely understand the good intentions behind this amendment, but Scottish Conservatives will be reserving our position on this vote pending the Cabinet Secretary's closing. And what we really need to hear, Cabinet Secretary, is an answer to Jamie Green's challenge to say why we have to vote for this, despite the representations that we've heard. We need to hear powerful, compelling reasons why we should vote for the Cabinet Secretary's interpretation of the law and reject the views that have been presented to us by the Law Society, by the Faculty of Advocates, by the Scottish Solicitors Bar Association, and why there is no alternative to stepping back and waiting for the Supreme Court judgment as was recommended to us. Presiding Officer.
Thank you. Call Pauline McNeill.
Thank you. In a similar vein, I'm not comfortable with this amendment. I think it is more than technical. I have listened to what the Cabinet Secretary spoke to, trying to understand it. And as I've understood it, what's been said is that you can't be convicted on docket evidence, but it could be used as corroboration. And I'm not wholly sure what that actually means in reality, because I've not had the chance to test it. It might be fairly straightforward, it might not be. It seems that Jamie Green is right. That is there another way of doing this that would allow us a chance to understand it first of all, and then understand the implications of it? Because what is the detriment if we don't do it? Liam Kerr is quite right. I mean, the operation of Section 274-275 is currently being considered by the Supreme Court in Dealey versus HMA. And if what I know of that case, it does seem to fall out with the boundaries of what the original Act set out to do. So I'm not clear why the provision has appeared at this stage. I'm not clear why the government has brought it now. Has something happened? Or is it just, all right, we'll just tag this on because, well, we can? So I'm not really comfortable with this. There's been no discussion nor understanding, because I don't even know what docket evidence is, to be honest, I mean, not being a practitioner. And I would have liked a chance to try and understand it. And I appreciate it might be straightforward, in which case I wouldn't want to stand in the way of the government doing something, you know, which needs to be done. But that's how I feel right now. That, and last, I think Jamie Green also made the point, what I do understand about docket evidence is that, rightly or wrongly, it can't be cross-examined. And I think that is the concern of the Scottish Bar Association, who are not saying it's the most outrageous thing or not saying it's really problematic, but they are saying that it can't be cross-examined. And we don't know if that's fair or unfair. I don't know if it's a simple matter or not. And I think the government really need to give us some understanding of why was it necessary to bring it now, and why couldn't it have been brought at least at stage 2, and we could have at least had time between stage 2 and stage 3. I mean, I know the government's under the same pressure as we are to some extent about the timescales we're all bound by, but they are so fast. They're so fast. I mean, when we're looking at all of this, we've got to go back and check all the letters that the government have sent us to clarify the position. It's a lot of work. And we really do, to throw this one in, I think, is problematic, but I'd like to hear justification. Thank you.
Thank you. As we are nearing the agreed time limit, I'm prepared to exercise my power under Rule 9.8.4a subsection C to allow the debate on this group to continue beyond the limit in order to avoid debate being unreasonably curtailed. And with that, I call on the Cabinet Secretary to wind up. Cabinet Secretary.
Thank you, Presiding Officer. Let me try and untangle this a bit. In terms of the points raised by members about why now, why are we bringing forward amendments around the extension of 274 to DASA victims where there's a sexual element and the docket witnesses. If I can just run through the history of this, the Lord Advocate initially raised this matter with my officials back in 2022. The Crown Office and Procurator Fiscal Service summarised these views in their written evidence to committee at stage 1 in regards to this bill. As for the committee, we originally shared our intention to lodge these amendments ahead of stage 2, and there was a letter sent to committee on the 4th of March. And the Lord Advocate reaffirmed her support for these amendments in her correspondence with committee on the 18th of March. So I just say that to give a bit of context that this issue, has not just arrived here at stage 3. It was our intention to bring it forward at stage 2. In terms of amendments 56 and 57, if I can be clear, they're not an extension of 274 protections for deceased. These are already in place, but without the amendments, the defence would not be able to make an application to lead evidence under 275. So these are technical amendments, and I would strongly recommend to Parliament that these technical and correcting amendments are passed so that we can continue to have a fair application of the 274-275 regime.
Liam Kerr.
Yeah.
To be absolutely clear with what the Cabinet Secretary is saying, is the Cabinet Secretary divorcing Amendment 56 and 57 from 55, such that parliamentarians may choose to vote against Amendment 55 if it's pressed, or are they inextricably linked?
Cabinet Secretary.
So, I'm just trying to bear with me. So, if I can just clarify that the purpose of Amendment 55 is twofold, and that is about extending the restrictions of 274 to docket witnesses and to DASA victims where there is conduct that amounts to sexual offences. I'm obviously in favour of passing all of these amendments, but I do reiterate that 56 and 57 are technical amendments that ensure that they rectify unintended consequences of earlier amendments at stage 2. And this was when we were changing the definition of complainer. And these technical amendments ensure that the new definition of complainer in section 275 of the Criminal Procedure Act, which clarifies that ILR is not available in respect of deceased complainers. So, in short, 56 and 57 are technical, and they are needed to protect the rights of the accused. 274 and 275 are part of a package, and yes, Amendment 55 is extending the 274 protections in a new way, and I emphasise that this issue is not, I wouldn't like it to be misrepresented that it's an entirely new issue at stage 3 when there is a history and committee has been informed of it. And just for the record, I spoke to it in my opening remarks that there is a debate by some around the 274-275 regime, and that some people have concerns about how these are applied by the courts. And the way to challenge that is through the courts, not, in my view, by attacking the legal framework which upholds the fundamental protection for both those whose sexual history and character has been called into question, as well as protecting the accused. There is a legal matter ongoing, but that should not be conflated with what we're trying to do with these amendments, and members will come to a view about whether or not they support the amendments.
Thank you. The question is that Amendment 55 be agreed to. Are we all agreed? No. Parliament's not agreed. There will be division, and members should cast their votes now. And the vote is now closed. Point of order, Liz Smith.
Voted no.
Thank you, Ms Smith. I'll make sure that is recorded. And the result of the vote on Amendment 55 in the name of Angela Constance is yes 63, no 48. There was one abstention. The amendment is therefore agreed. I call Amendment 56 in the name of the Cabinet Secretary, already debated with Amendment 55. Cabinet Secretary to move formally.
Moved.
Question is Amendment 56 be agreed to. Are we all agreed? That is agreed. I call Amendment 57 in the name of the Cabinet Secretary, already debated with Amendment 55. Cabinet Secretary to move formally.
Moved.
Thank you. The question is that Amendment 57 be agreed. Are we all agreed? Yes. We are agreed. It takes us to Group 20, non-harassment orders and protective orders made out with Scotland. I call Amendment 3 in the name of Shan Dowie. Group with Amendments 147, 147A, 148, 149, 150, 151, 164 and 165. Shan Dowie to move Amendment 3 and speak to all amendments in the group. Ms Dowie.
Thank you, Presiding Officer. Non-harassment orders are a vital tool in protecting victims from further harm. They can be used to prohibit an offender from contacting or approaching a victim and so enable the police to intervene to prevent further harassment, even where the offender's behaviour might not otherwise constitute a criminal offence. Amendment 3 extends the duty that currently applies in domestic abuse cases, where the courts must always consider whether to make an NHO to protect the victim, without the need for the prosecutor to make an application to the court, so that it will also apply in all cases involving sexual offences, stalking and intimate image abuse. By requiring the court to consider an NHO in these cases, this amendment ensures that the court must actively consider in every case whether an NHO is required to protect the victim, and must make an NHO unless they consider that it is not necessary to do so to protect the victim. In addition, members may be aware that NHOs in domestic abuse cases can make provision in favour of a child who normally resides with either the victim or the perpetrator, or both. In view of the fact that stalking offences also often involve a perpetrator who is fixated on the victim and may seek to target their family to continue to abuse the victim, this amendment extends that power to cover people convicted of stalking as well. I know that members across the Chamber share a commitment to strengthening protections for victims, and I move Amendment 3. Thank you.
Thank you. I call Pam Gosnell to speak to Amendment 147 and other amendments in the group. Ms Gosnell.
Thank you, Presiding Officer. Before I speak to my Amendment 147 and 147A regarding domestic abuse, I want to put on record that I am grateful to the Scottish Government for the advice that they gave to support my amendments on non-harassment orders, particularly to remove Section 2 from Amendment 147, hence why I have asked for a manuscript amendment, and I am also grateful to the Presiding Officer. Now to speak to my amendments. Presiding Officer, even though I believe that the Victims, Witnesses and Justice Reform Bill has many shortcomings, I have proposed the following amendments with hopes of improving this bill. My amendments 147 and 147A address a serious gap in protection for survivors of domestic abuse. I was recently contacted by families outside an organisation works to support families affected by imprisonment. They told me about a legal gap where bail conditions such as non-harassment orders are put in place to protect survivors but expire once an offender is sentenced. As a result, if a non-harassment order is imposed in these cases, the victims of these crimes are left vulnerable, with the perpetrator still able to contact them from prison. Shockingly, they report that some victims are coerced into contact with their offender as a result. That is why my Amendment 147 would require courts to consider the fact that bail conditions were imposed when deciding whether to issue a non-harassment order in a domestic abuse cases, including where the offender is imprisoned or remanded in custody. My Amendment 147A makes a minor change to ensure that this requirement applies only in domestic abuse cases. These amendments would ensure survivors of domestic abuse continue to be protected, and I urge members to support them. I hope the Scottish Government finds some common sense and makes the right choice to support these amendments, along with other Scottish Conservative amendments, and truly transform victims' rights. I now turn to support Amendment 3 in the name of my colleague Sharon Dowie, which rightly requires a court to consider imposing non-harassment orders without the need for the prosecutor to make an application to the court in all cases involving sexual offences, stalking and intimate image abuse. During stage 2 of the bill, I submitted an amendment alongside Sharon Dowie with the intention of making it mandatory to impose non-harassment orders in sexual offence cases. While the Government did not support this, I am glad that the Cabinet Secretary has reached a compromise with us instead to make it mandatory for the courts to consider imposing a non-harassment order in these cases. Over the summer recess, I met with Action Against Stalking, an organisation which helps survivors of stalking regain control of their lives. They were clear that stalking is a terrible crime and often goes hand in hand with other offences such as domestic abuse and can leave survivors scarred for life. That is why I am particularly pleased that the offence of stalking has been added to the amendment and that it will rightfully extend the power that the courts have to make provisions to protect children who are impacted by stalking cases. I believe that this amendment will help survivors, and I am proud to support it today, and I hope members do too. Thank you.
Thank you. I call Maggie Chapman to speak to Amendment 148 and other amendments in the group.
Thank you, Presiding Officer. I'd like to begin my comments on this group by recognising the work of and tireless campaigning by Amelia Price. Her dedication to see change in how non-harassment orders operate, not just for her, but for victims and survivors in the future, show just her true dedication to this. She doesn't want anybody else to go through what she went through. I have 3 amendments in this group, 148, 149 and 150, and I'll speak to them in turn. 148 turns what are optional NHOs into mandatory non-harassment orders. The need for this has been recognised for a long time. Indeed, the Criminal Justice Committee discussed this in 2017 at Stage 2 of the Domestic Abuse Bill, when Linda Fabiani proposed an amendment calling for mandatory non-harassment orders. It was supported by John Finney and Scottish Women's Aid. Linda Fabiani had heard what she described as compelling evidence and quoted a survivor, who I'll quote again this evening. A criminal conviction was of absolutely no use to me as a victim, since that conviction on its own contained no provision to protect me from further abuse. But that wasn't enough to change people's minds 8 years ago. Amelia Price, dedicated campaigner on this issue, says that those words still resonate with her. She asked about NHOs granted in cases of rape against a partner. The Scottish Government said it doesn't have this information. And about domestic abuse cases, while we know numbers have increased, there are still more cases when NHOs are not granted than those where they are. Amelia's own story is that her former partner was sentenced to a 49-month custodial sentence after being unanimously found guilty of assault and rape by strangulation. An NHO was not granted on grounds that Amelia had moved to England and that her abuser hadn't contacted her while on bail, but one of his bail conditions was that he was prohibited from doing so. Neither of these factors were relevant to her risk after the trial, and a Casey referring to it said clearly, there are unlimited ways that an offender can harass a person in England from a location in Scotland. As to the second, that strikes me more as an argument for making an order. The last order worked. In Amelia's words, in the sentencing statement for my case, Lord Boyd references the online abuse and humiliation I suffered at the hands of my abuser, which ultimately was the cornerstone of his conviction. He didn't attempt to contact me on bail when there was the deterrent of custody, but without this deterrent, I have no doubt that he will. I do not need to live in Scotland for digital abuse to continue, and therefore the judge has been negligent in choosing not to eliminate that risk if it was at his disposal to do so. My Amendment 149 seeks clear sentencing guidelines on the use of non-harassment orders from the Sentencing Council. Now, I appreciate that this demand is maybe beyond that which we should be making of the Council. And I would ask the Scottish Government for any clarification or confirmation that they might be able to give around this on engagement with the Council on this issue. On my Amendment 150, this seeks a report on non-harassment orders, their use, how many have been issued, for which offences, those that have been applied but not issued, and so on. I firmly believe that we need to be collecting and monitoring this information. It is correct that the number of NHOs issued has increased in recent years, but we still don't know the details or reasons for these, or for when NHOs are not made. Now, I am aware that the Cabinet Secretary will ask me not to press this amendment, given the volume of work required. However, I hope that she will be able to recognise the need to get to grips with this important tool, that of NHOs, that should be being used to protect victim survivors, and that there will be further work in this regard. Thank you.
Thank you. And I call Rona Mackay to speak to Amendment 151 and other amendments in the group.
Thank you, Presiding Officer. Amendment 151 addresses a gap in the law concerning the ability of police, prosecutors and courts to enforce certain protective orders imposed in other jurisdictions of the UK. Members may be aware of a recent case in which a person residing in Scotland found that conditions contained in a restraining order made by a court elsewhere in the UK against a person convicted of abusing them could not be enforced in Scotland, and that's clearly unacceptable. This highlighted a wider issue with the law that needs to be resolved, and I'm using this bill today to address that. A protective order, such as a restraining order, can stop an individual from doing a range of things. This might include things that otherwise would be legal, such as approaching a victim or contacting a victim. In these types of situations where behaviour amounting to a breach of a condition are not criminal acts, then protecting the victim through the restraining order cannot take place in Scotland, and that is what Amendment 151 will change. Amendment 151 will make it an offence for a person to knowingly and without reasonable excuse do anything which they are prohibited from doing by a relevant UK order, or fail to do something which they are required to do by a relevant UK order. And those relevant UK orders are restraining orders, non-molestation orders and stalking prevention orders imposed by courts in England, Wales or Northern Ireland. The maximum penalty for this offence on conviction of indictment is 5 years imprisonment, unless the maximum penalty for the equivalent offence for breach of the order under the law applicable in that jurisdiction is lower, in which case that is the maximum penalty. The amendment includes the power, subject to affirmative procedure, for Scottish ministers to add to the list of protective orders covered by this offence. This could be used if there are changes to relevant legislation in other jurisdictions of the UK. My Amendment 165 amends the long title of the bill to reflect Amendment 151. Presiding Officer, I ask members to support Amendments 151 and 165.
Thank you. And I call the Cabinet Secretary to speak to Amendment 164 and other amendments in the group.
Presiding Officer, the amendments in this group are on the important issue of protection for victims, and I am pleased that I have been able to work with members on this important issue. And even for those that I don't support in the name of Maggie Chapman, I do welcome her continued and constructive engagement on this issue. I have been able to work with Sharon Dowie on her Amendment 3, which ensures that courts must consider non-harassment orders, or NHOs, in cases involving sexual offences, stalking and intimate image abuse. I am sure all will be able to support this amendment and Pam Gossell's Amendment 147, subject to Amendment 147A being passed. Presiding Officer, as I've said, unfortunately I cannot support Maggie Chapman's amendments. In the case of Amendment 148, my main objection is that there are considerable legislative competence concerns, as it would remove prosecutors' discretion by requiring them to apply for an NHO in every case where an offender is convicted of what the amendment calls misconduct towards another person. This interference with the independence on how prosecutors on behalf of the Lord Advocate conduct prosecutions is out with the legislative competence of the Parliament. Even if this wasn't the significant concern it is, the term misconduct is likely to capture a wide range of offences, potentially even including fraud and theft, even where there is no direct contact between offender and victim. and this amendment could impact on around 30% of all convictions in Scottish courts. This would therefore dramatically increase the number of cases requiring judicial consideration of NHOs, placing unsustainable pressure on both the Crown Office and the Scottish Courts and Tribunal Service, and risk diverting resources away from those cases where consideration is most needed. There is already a requirement for the courts to consider imposing an NHO on all domestic abuse cases, and if agreed, Sharon Dowie's Amendment 3 will extend this to cover those convicted of sexual offences, stalking and intimate image offences. I can reassure Parliament that the current system allows the Crown Office and Procurator Fiscal Service to exercise discretion to apply for NHOs where appropriate in all other cases involving misconduct towards the victim, and this strikes a sensible balance by focusing the court's attention on those cases where an NHO is most likely to improve victim safety. Presiding Officer, Ms Chapman's Amendment 149 would mandate the Scottish Sentencing Council to prepare sentencing guidelines on the use of non-harassment orders. While Amendment 149 is well-intentioned, it is for the Independent Council to decide their own priorities, and their current business plan includes progressing guidelines in the areas of sexual offences and domestic abuse, exactly the type of offences where NHOs are often imposed by the court. In addition, the Scottish Ministers already have power to request that sentencing guidelines be prepared on any matter. This means that there are existing routes which do not require legislation in order to feed into the Council's programme of work. Therefore, I can commit to the Member and Parliament that I will write to the Council this week to request that they confirm they will consider the use of NHOs as part of their work on these guidelines, and this will include making as much relevant information and data available as possible. Ms Chapman's Amendment 150 would require the Scottish Ministers to report annually on matters relating to the use of NHOs by the criminal courts. However, this would require reporting on matters about which information is unlikely to be available. For example, cases in which the victim asked for an NHO and the court declined to make one cannot be recorded, as there is no formal mechanism in law for victims to request that the court make an NHO. Of course.
Maggie Chapman.
The example that the Cabinet Secretary has just given, where somebody requests an NHO and it is not granted, surely that's exactly the kind of cases that we should be gathering information on, so we can better understand the need and whether there are other mechanisms of protection that we can provide for victim survivors.
Cabinet Secretary.
Presiding Officer, I don't disagree with Ms Chapman's point of principle. I suppose I'm merely pointing out that her amendment is asking us to do something in which there is no current mechanism existing. But the broader point is that the information that Ms Chapman is seeking is not information that can or would come from the Scottish Government, but from the courts. And the courts have established systems for operational purposes to manage cases as opposed to gather data. But saying that, I do very much appreciate her point about the lack of available data. I think that's an important and considered point and a fair point that she's made, and it will be something that I will raise directly with the Scottish Courts and Tribunal system when I next meet the Chief Executive. I would therefore urge Ms Chapman not to press the amendments in this group, and if they are pressed, for Parliament to oppose. Presiding Officer, I would like to thank Rona Mackay for working with me on Amendment 151. As she has outlined, there is currently a gap in the law which arises where a court in England, Wales or Northern Ireland imposes a protective order that is breached in Scotland. Amendment 151 introduces a direct enforcement model and ensures that an individual will be protected if they are in Scotland in the same way that they are in the jurisdiction in where the order is made. And I welcome this additional protection, closing an identified gap, and urge members to support. And finally, Amendment 164 and 165 are minor consequential amendments relating to Amendments 3 and 151, and I would ask members to support. Thank you.
Thank you, and I call Sharon Dowie to wind up and press or withdraw Amendment 3.
No further comments, and I'll press.
Thank you. The question is that Amendment 3 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 147 in the name of Pam Gossel, already debated with Amendment 3. Pam Gossel, to move or not move?
Moved.
Thank you. I call Amendment 147A in the name of Pam Gossel, already debated with Amendment 3. Pam Gossel, to move or not move?
Moved, Presiding Officer.
Thank you. The question is that Amendment 147A be agreed to. Are we all agreed? Yes. We are agreed. Pam Gossel, to press or withdraw Amendment 147 as amended?
Press.
The question is that Amendment 147 as amended be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 148 in the name of Maggie Chapman, already debated with Amendment 3. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 148 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. I call Brian Whittle for a point of order.
Sorry, Presiding Officer, my app wouldn't connect. I would have voted no.
Thank you, Mr Whittle. We'll ensure that's recorded. The result of the vote on amendment number 148 in the name of Maggie Chapman is yes 12, no 101. There were no abstentions. The amendment is therefore not agreed. I call amendment 149 in the name of Maggie Chapman, already debated with amendment 3. Maggie Chapman, to move or not move?
Not moved.
Thank you. I call amendment 150 in the name of Maggie Chapman, already debated with amendment 3. Maggie Chapman, to move or not move?
Moved.
The question is that amendment 150 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 150 in the name of Maggie Chapman is yes 52, no 61. There were no abstentions. The amendment is therefore not agreed. I call Amendment 151 in the name of Rona Mackay, already debated with Amendment 3. Rona Mackay, to move or not move?
Move.
The question is that Amendment 151 be agreed to. Are we all agreed? We are agreed. I call Amendment 152 in the name of Maggie Chapman, already debated with Amendment 108. Maggie Chapman, to move or not move?
Moved.
I call Amendment 152A in the name of Maggie Chapman, already debated with Amendment 108. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 152A be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 152B in the name of Maggie Chapman, already debated with Amendment 108. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 152B be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 152C in the name of Maggie Chapman, already debated with Amendment 108. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 152C be agreed to. Are we all agreed? Yes. We are agreed. Maggie Chapman, to press or withdraw Amendment 152 as amended.
Pressed.
The question is that Amendment 152 as amended be agreed to. Are we all agreed? Yes. We are agreed. And we move to Group 21, Review of Act. And I call Amendment 1 in the name of Pauline McNeill, grouped with Amendments 2, 153, 154, 155 and 156. Pauline McNeill, to move Amendment 1 and speak to all amendments in the group.
Thank you. Amendments 1 and 2 expand the reporting requirement in section 66E of the bill. I thank the Government for working with me on this amendment. At stage 2, I highlighted the importance of Parliament maintaining scrutiny of the law of corroboration, which of course the courts may continue to develop. On the 30th of October 2024, the High Court of Justiciary Appeal published a judgment on how corroboration is used in Scottish criminal trials, and the judgment was published after the Lord Advocate had asked the court to review how corroboration is used, specific requirements for corroboration in sexual offences cases. This judgment sets out from now on, while corroboration is still required, there is no requirement to prove the separate element of a crime by corroborated evidence. So the change means that distress which is observed by a third party can corroborate a complainer's account that they have been raped. Penetration does not need to be corroborated separately. And Rape Crisis said it was a seismic change in the approach to corroboration in sexual offence cases in Scotland. So currently section 66E of the bill requires Scottish ministers to undertake 2 reviews of the operation of the bill once enacted. The first review must be concluded as soon as reasonably practical 5 years after royal assent, and the second must be concluded 5 years after the first review. Ministers must prepare a report on each review, which they must publish and lay in the Scottish Parliament. The effect of amendments is that each report must also cite any changes to the law relating to corroboration that have taken place during the review period. Thank you.
Thank you. I call Katie Clark to speak to Amendment 153 and other amendments in the group.
Thank you, Presiding Officers. My amendments in this group have been lodged following on from previous amendments I lodged at stage 2 of this bill on independent legal representation for rape victims, and also further to discussions with the Scottish Government. And I'm grateful to the Scottish Government and their officials for their engagement. I speak to amendments 153, 155 and 156. I will not be moving Amendment 154. Amendment 153 requires the Scottish Government to set out measures to improve the experience of women in the review of this legislation. Amendments 155 and 156 expand the reporting requirements on the Scottish Government to require engagement with the lived experience of women. These amendments, following on from representations I made at stage 2 relating to an extension of independent legal representation and advocacy for rape victims to empower survivors within the justice system. My amendments seek to ensure that there is continued consideration on the impact of the welcome measure included in this bill to allow advocacy in the court when access to medical records is being sought by the defence, and indeed other initiatives such as the legal advice work being undertaken at Glasgow University. We hear repeatedly that rape victims find the justice system re-traumatising. In many other jurisdictions, there has been a significant expansion in independent legal representation over recent decades, which has helped to empower victims. Scotland is still lagging behind much of Europe and indeed many other parts of the world when it comes to legal representation of victims. For example, in Denmark and Norway, victims are entitled to legal representation at the reporting stage before and during trial. In Spain, the law allows female victims of gender violence free legal assistance regardless of the existence of resources to mitigate. And many other legal systems, some similar to ours, some less so, outside of Europe also provide legal representation for victims. I move my amendments 153, 155 and 156 and hope that in the review of this legislation there is further consideration to expand independent legal representation, advice and advocacy for rape victims and indeed other victims. Thank you, Presiding Officer.
Thank you. I call the Cabinet Secretary.
Presiding Officer, I am pleased to support all of the amendments in this group apart from 154, which Katie Clark has confirmed she is not pushing. I recognise Pauline McNeill's views on continuing monitoring developments and corroboration, which is a distinctive part of our criminal law that has been refined and modernised by the courts for decades. I confirmed to Pauline McNeill at stage 2 that the Government would engage with her on how best to achieve this, and I am pleased we've been able to work together on the amendments. Presiding Officer, I am proud to be taking forward a bill containing landmark reforms that will improve how survivors of sexual offences, the majority of whom are women and girls, are treated within our justice system. And Katie Clark's amendments ensure that the review of the Act considers, in particular, the experiences of women who are victims and witnesses. And I'm happy to support amendments 153, 155 and 156 in her name.
Thank you. I call Pauline McNeill to wind up and press or withdraw Amendment 1.
Thank you. In conclusion, Presiding Officer, I want to thank the Cabinet Secretary for working with me on this, and because I do think it's important, and I didn't say from the outset that the interaction between the new provisions of removing the not proven verdict and the very finite balance of the new jury size, then it's really important to continue to review the different elements, and corroboration being a significant part of that is one of the reasons why I felt that it should be reviewed. And with that, Presiding Officer, I move.
Thank you. The question is that Amendment 1 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 2 in the name of Pauline McNeill, already debated with Amendment 1. Pauline McNeill, to move or not move?
Moved.
The question is that Amendment 2 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 153 in the name of Katie Clark, already debated with Amendment 1. Katie Clark, to move or not move?
Moved.
Thank you. The question is that Amendment 153 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 154 in the name of Katie Clark, already debated with Amendment 1. Katie Clark, to move or not move?
Not moved.
Thank you. The amendment is not moved. I call Amendment 155 in the name of Katie Clark, already debated with Amendment 1. Katie Clark, to move or not move?
Moved.
Thank you. The question is that Amendment 155 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 156 in the name of Katie Clark, already debated with Amendment 1. Katie Clark, to move or not move?
Moved.
The question is that Amendment 156 be agreed to. Are we all agreed? Yes. We are agreed. We move to Group 22, changes to jury size and verdict. And I call Amendment 157 in the name of Pauline McNeill in a group on its own. Pauline McNeill, to move and speak to Amendment 157.
Thank you very much. Amendment 157 ensures that specific training is given to judges, sheriff principals, sheriffs and members of staff in the Scottish Courts and Tribunal Service before the change in the jury size comes into effect. I'm pretty certain the Government will oppose this. I just want to be honest with the Chamber and say that I know it's 8:30 in the evening and you're all tired. It's been a long day for everyone, but I want to draw to your attention that one of the issues that the Government and the committee were wrestling with in this bill was the removal of the not proven verdict, which had widespread agreement But there was quite widespread disagreement on the size of the jury. And if I hadn't put this amendment, that it would not have been mentioned at stage 3 at all. I'm sure we'll debate it tomorrow. So maybe it's not the right way forward to say that there should be training, but I think it certainly should be recognised that if this bill is passed, we will have a fundamentally different system, jury system. For the better or for worse, we will not know until it's enacted. And the government went from a jury size of 12 to a jury size of 15, with a majority of 10. Not everyone agreed with that. So I think it's important to highlight this, and I think there should be some way that the government should mark how this is going to be taken forward. I mean, the government has set out their sort of timescale for which powers they'll take down, because this is a massive bill. When they would take the powers to enact what aspect of it. But I think in doing so, I think it has to be recognised this will be a different way of juries coming to certainly different numbers, different ways of juries coming to their decisions. And I don't plan to move it, but I just felt if I hadn't put it, there would have been no debate on something which is really taking a long time to come to pass, actually. And it's very significant. Thank you.
Thank you. I call Christine Graham.
Yes, thank you very much, Presiding Officer. And I very much thank Pauline McNeill for bringing this, because we've hit on one of the most radical parts of the bill. And you quite rightly say, as it's not subject to amendment, we'd have no opportunity to discuss it here. We're changing, of course, the not proven verdict, removing it from both solemn and summary proceedings in most criminal proceedings. The one thing I wanted to add here is that my concern that there appears to be a presumption that abolishing not proven, with changes to the jury majority, and we don't quite know how these will interact, will lead to more convictions. Not saying that's the purpose, but there's a presumption this will happen. I don't think that can be presumed. Not proven, I'm teaching my granny to suck eggs here, means the Crown has failed to prove its case beyond reasonable doubt, the onus being on the Crown with its evidence to establish its case. To me, it obviously follows that not guilty meets the same test, beyond reasonable doubt. Doubt in the mind, quite rightly, of sufficient jurors must lead to not guilty. I therefore do not necessarily see an increase in convictions, bearing in mind too, while much of this bill focuses on sexual offences, quite rightly, these radical changes apply across most crimes and as to whether there is a jury or a sheriff sitting alone. So I hope abolishing not proven does not disappoint victims, especially those with have had serious crimes against them, who may think that a conviction is more likely. I do not think that that necessarily follows. And controversially too, not proven has been described as being unjust to the accused and unjust to the victims. However, and this is my story, I was a victim and the main witness in a summary trial where the Crown pursued a conviction against a constituent who had intimidated and harassed me for years. And there was, in my view, sufficient evidence for a guilty verdict. But to my astonishment, the verdict was not proven. Now, at first, I was furious. However, on reflection, I must say I preferred that to not guilty. Now, I've lost that argument, not proven, not guilty, proven. The three verdicts have gone. But it's just by way of telling you there were... Yes?
John Mason.
Thank you. I follow her argument with interest because I also feel that the not proven verdict to some extent is a more honest verdict, whereas not guilty, somebody may have got off on a technicality or all sorts of reasons. So would she say that at least there's a strong argument for the two being proven and not proven, although I accept that we've lost that argument?
Christine Graham.
Well, I'm not going to fight a battle that's been lost. It's a waste of my energy. But I'm just presenting the case that somebody being found not proven from the victim's point of view was not always bad news. And that sword of Damocles went over the head of that gentleman and he stopped his misbehaviour so far. So while I say, yes, we'll just have the two verdicts, but please, let's not presume that this will lead to more convictions. It may very well be neutral at best. Thank you.
Thank you. I call the Cabinet Secretary.
Presiding Officer, Ms McNeill is correct. I'm afraid I cannot support her amendment 157. Under the Judiciary and Court Scotland Act 2008, the Lord President is responsible for the training of the judiciary. It would not be constitutionally appropriate for ministers to pass judgment on judicial training. There are also some drafting issues with the amendment, and it's not clear by what is meant by sufficient training or the level of detail about the training which is to be supplied to the Parliament. Presiding Officer, abolishing not proven is indeed a significant step for this Parliament, and I am pleased that there has been cross-party support for this change from the 2021 manifestos, Labour, Tory, Green, SNP, that has permeated through to support during the bill's passage. The issues are, of course, complex, but they have been thoroughly and carefully scrutinised, particularly by those on the Criminal Justice Committee. And as we are on the last grouping, let me take this opportunity to thank them for their considered engagement throughout the bill process. And I'll just briefly say to Christine Graham that this part of the bill is about modernising our system. Not proven is a widely misunderstood verdict. It traumatises victims because it is a verdict that they don't trust or understand. And, of course, it leaves a lingering stigma on the accused. And to John Mason's point, there is, of course, an argument to have the two verdicts as proven or not proven. I have to say, to my surprise, nobody really made that argument during the passage of the bill, and there's been no amendments to that effect. But the two verdicts of guilty and not guilty are unambiguous and clear and had the most support in the consultation that was led on this bill. And just if I can finish, Presiding Officer, by... OK, thank you.
Christine Graham.
That sounded a resignation to it. Does the Cabinet Secretary consider this may lead to more convictions?
Cabinet Secretary.
The purpose, and let me be clear to Ms Graham, of this part of the bill is neither to decrease or increase convictions. It's to ensure that we have balance in the system, and it's about modernising our system and ensuring that there is transparency in terms of decision-making processes. I'm sure we will debate not proven more tomorrow. It is, in my view, a reform that is long overdue. And if I can just finish by saying, Presiding Officer, as we finish the amendments on this landmark bill, let me pay tribute to victims, families and support organisations who have shaped it, including those who have campaigned for the abolition of the not proven verdict for many years. It is now time to act and implement the reforms in this bill. And I look forward to our continued debate tomorrow. And in the meantime, I ask Pauline McNeill not to press Amendment 157, and if she does, I ask Parliament to vote against it.
Thank you. Pauline McNeill to wind up and press or withdraw Amendment 157.
Thank you. I don't intend to press that, but I think Christine Graham's or some of the contributions there, I think, demonstrated why it's still worth having the debate, because, Christine Graham, you're absolutely right. Depending on who you speak to, you'll get a different answer. The Lord Advocate, she gave evidence to the committee saying she thought it would be harder to get a conviction, where others think. I wholly appreciate where the government were trying to come from here, which is they try to maintain the balance, if you can achieve such a thing. And the bill was published with, this is the point I wanted to make, the bill was published with 12 jurors, and the conviction would be on 8 jurors. And now we have 15 jurors. I think it's probably right for the government to do that, but I think it has to be noted that Scotland will still be an outlier. So that was one of the arguments about not proven. So just bear that in mind, you know, when you're voting on the bill tomorrow. I am comfortable with it because I think that the criminal justice system, once you more examine it in Scotland, has got many differences with the English system, many differences with other jurisdictions, and it's just something that's grown over many years. But yes, it has to be modernised, and I totally accept that. And yes, it was our position that we should remove the not proven verdict. In fact, if I remember rightly, it was first attempted by Michael McMahon in a very early Parliament, who had the Members' Bill. But I'm sure if he's listening, he'll be pleased about finally coming to it. So we don't know, but I wanted to conclude on this. I hope the Cabinet Secretary would agree that a future Parliament does need to have a look at jurors and how valued they should be. There's not been much work done about, we've talked about juries and jury myths and everything that expected of juries, but without juries, we can't run our criminal justice system. And if you spoke to anyone who's served in a jury, you know, there's a lot of negative feedback about serving as a juror, and I think it's maybe work for a future government that we must recognise the importance and value our jurors, and I will not be pressing.
Thank you. Pauline McNeill seeks to withdraw Amendment 157. Does any member object? No member objects, and the amendment is withdrawn. I call Amendment 58 in the name of the Cabinet Secretary, already debated with Amendment 6. Cabinet Secretary to move formally.
Moved.
Thank you. The question is that Amendment 58 be agreed to. Are we all agreed? We are agreed. I call Amendment 94 in the name of the Minister, already debated with Amendment 66. Minister to move formally.
Move, Presiding Officer.
Thank you. The question is that Amendment 94 be agreed to. Are we all agreed? We are agreed. I call Amendment 95 in the name of the Minister, already debated with Amendment 66. Minister to move formally.
Move formally.
Thank you. The question is that Amendment 95 be agreed to. Are we all agreed? I call Amendment 158 in the name of Pauline McNeill, already debated with Amendment 109. Pauline McNeill to move or not move?
Not moved.
Thank you. I call Amendment 159 in the name of Pauline McNeill, already debated with Amendment 109. Pauline McNeill to move or not move?
Not moved.
Thank you. I call Amendment 160 in the name of Pauline McNeill, already debated with Amendment 109. Pauline McNeill to move or not move?
Not moved.
Thank you. I call Amendments 161, 162, 163 and 164, all in the name of the Cabinet Secretary and all previously debated, and I invite the Cabinet Secretary to move Amendments 161 to 164 en bloc.
Moved en bloc.
Thank you. Does any member object to a single question being put on Amendments 161 to 164? No member objects. The question is that Amendments 161 to 164 are agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 165 in the name of Rona Mackay, already debated with Amendment 3. Rona Mackay to move or not move?
Move.
And the question is that Amendment 165 be agreed to. Are we all agreed? Yes. We are agreed, and that ends Stage 3 consideration of amendments. And as members will be aware, I am required under standing orders to decide whether or not, in my view, any provision of a bill relates to a protected subject matter, that is, whether it modifies the electoral system and franchise for Scottish parliamentary elections. And in the case of this bill, in my view, no provision of the Victims, Witnesses and Justice Reform Scotland Bill relates to a protected subject matter. Therefore, the bill does not require a supermajority to be passed at Stage 3. And there are no questions to be put as a result of today's business, and I close this meeting.